Good morning, all. This hearing is in the matter of CFI-022-2025, CFI-025-2025, and CFI-035-2025, and is being held by way of video conferencing before His Excellency Justice Roger Stewart, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Nurhan Abdul Latif Al Zabi Advocates and Legal Consultants. Lead counsel is Ms. Maryam Razak. The defendant is represented by Nisma Al Janahi Advocates and Legal Consultants. Lead counsel is Mr. Tamam Al Garawi. Thank you, Your Honor.
Thank you. Good morning.
Good morning.
Is everyone ready to go? Very good. In that case, I think it's probably for the defendant to start.
Your Honor. First of all, good morning to Your Honor and opposing counsel. May it please the court, I appear on behalf of the defendant, Sadapay Technologies Limited. This is the defendant's application to dismiss the claimant's claim. The grounds are twofold. First, that the DIC courts lack jurisdiction because the parties expressly agreed otherwise. And second, that even if jurisdiction were somehow found, the claim is out of time under the DIC employment law. Both points are decisive, and taken together, they leave the court with no jurisdiction to hear this matter, and no lawful basis to allow the claim to proceed. Firstly, I will deal with the jurisdiction and applicability of the DIC employment law. The claimant leans heavily on Goel and Credit Suisse Switzerland Limited, 2012. The claimant suggests that the case stands for a sweeping principle that statutory DIC jurisdiction cannot be ousted by a foreign jurisdiction clause. That is not correct. It is an inaccurate and, with respect, somewhat misleading characterization. Goel was concerned with the generic phrase courts of Dubai. The Court of Appeal held that this phrase encompassed the DIFC courts because there was no explicit opt-out. The principle was that in the absence of clear wording, the DIFC courts remain included. The claimant's reliance on Goel is therefore misplaced. The present contract does not use generic forum wording. It expressly states that disputes shall be governed by Pakistani law and resolved in the courts of the Islamabad Capital Territory. That is a deliberate and explicit opt-out, entirely different from the clause considered in Goel. This is not a case of ambiguity. It is a case of freedom of contract exercised clearly and unequivocally. The claimant asks the court to disregard that bargain, and in doing so undermines the very principle of party autonomy. In any case, the correct statutory gateway for determining the applicability of the DIFC employment law is in the law itself in Article 4, which states that the law applies only where an employee is based in or ordinarily works in or from the DIFC, or the employment contract explicitly opts into DIFC law. These gateways are intentionally narrow. They are designed to confine the reach of DIFC employment law to those genuinely connected to the DIFC, not to allow global employees to invoke DIFC law whenever convenient. The claimant cannot meet either condition. Firstly, the claimant was never based in the DIFC, nor did the claimant ordinarily work from the DIFC. At most, the claimant made occasional visits to the DIFC office, which is a far cry from being based in or ordinarily working in or from the DIFC. Secondly, the claimant's employment contract does not opt in to DIFC law. To the contrary, it opts out by choosing Pakistani law, and it does so expressly and unambiguously. That is the law of the contract, and it must be respected. The claimant attempts to rely on incidental factors and points to contributions made to dues, exhibited as Claimant's Exhibit 13, and to the claimant's Emirates ID, exhibited as Claimant's Exhibit 12. These are not determinative for two reasons. Firstly, the dues contributions are an incidental employment benefit. They do not alter the place where the employee actually performed his work, nor do they override the clear jurisdiction clause. Secondly, an Emirates ID proves only that the claimant was given a local credential to facilitate infrequent visits to the DIFC office. It was an administrative tool, not a jurisdictional anchor. It does not prove that he was based in or ordinarily worked in the DIFC. The defendant notes that out of all the potential evidence, including witness testimony that could have been put forward, the claimant only put forward these two pieces of evidence. This indicates that in reality, no other evidence could have been put forward, and the claimant is only using these two unsubstantial pieces of evidence in a desperate attempt to salvage their claim. The claimant also says the dispute arises from a share incentive plan, allegedly governed by DIFC law and therefore must fall within DIFC jurisdiction. This too is incorrect. The dispute is about an employment benefit, i.e. stock options, that existed only because of the employment relationship. Clause 4 of the employment contract, exhibited as Defendant's Exhibit 1, itself identifies the options as part of the employee's compensation package. Without the employment contract, there would be no share incentive plan or grant agreement. The core of the claim is an employment law claim about an employment benefit, not a standalone contractual dispute. Furthermore, the claimant misstates the governing law of the grant agreement in their skeleton argument. That document is governed by the laws of England and Wales, not the DIFC law. The claimant's attempt to tether the dispute to the DIFC law by reference to the grant agreement is factually and legally wrong. In the alternative argument, I will now make two arguments in relation to the time-barred nature of the claimant's claim. The claimant argues the claim is timely because of what he describes as Article 12, Paragraph 2 of the DIFC employment law, which I believe is a citation error and is actually a reference to Article 20, Paragraph 2. He quotes it as if it provides a 6-month period running from the date the employee became aware of a breach. This is inaccurate. The actual specific reference is Article 20, Paragraph 2, Subparagraph A1, which deals with unlawful deductions and remuneration claims. That article requires that such claims be brought within 6 months of, quote, the date on which that remuneration should have been paid. It contains no knowledge-based trigger. The clock runs from the due date, not discovery or awareness. The defendant maintains that Article 20, Paragraph 2 does not in fact apply to this case, but even if it does, the correct date is 19 August 2024, the day the defendant exercised its company call option and repurchased the claimant's vested shares at $0.001 per share. That was the point when the fair market value of the stock options was decided and informed to the claimant. Firstly, there were no unlawful deductions. And secondly, the remuneration, being the value of the shares, was paid at the price the defendant specified, as the defendant is entitled to do in its sole discretion to decide the fair market value of the shares. Therefore, any dispute is in relation to what the fair market value is, not whether the remuneration was paid. Article 22A1 does not envision such a dispute within its scope, simply whether the remuneration has been paid or not, which it has. Secondly, the claimant's contention that the breach only became apparent on 9 September 2024 is unsustainable. The company call option dated 19 August 2024 clearly specifies the purchase price of the shares at a value of $0.001 per share. To postpone the start of the limitation period until nearly a month later, to 9 September 2024, when this was confirmed, is absurd. If we were to take the claimant's own logic with regards to knowledge of the breach and apply it, then the alleged breach happened on 19 August 2024, not when the alleged breach was confirmed by email on 9 September 2024. Thus, even if Article 20, Paragraph 2 applies, the limitation period expired on 19 February 2025. The claim was filed on 28 February 2025, 9 days late. So, under the strict approach of the DIFC courts, lateness of even a few days is fatal. My second argument is in relation to the claimant's termination date. The claimant also mischaracterizes the termination of his employment. He resigned on 4 July 2024, exhibited as Defendant's Exhibit 2. Under Clause 6 of his contract, the notice period is 30 days. His employment therefore terminated on 3 August 2024 as a matter of law. That is the date on which the limitation period timeframe begins to run for Article 10 purposes. The defendant did allow him to remain on a so-called extended garden leave until 31 August 2024, but this was not a true garden leave under the contract. It was a discretionary goodwill extension offered by the CEO during a difficult period for the company. It was akin to severance pay, not a contractual continuation of employment. The law of the parties is contained in the contract. The contract was never varied or extended. The notice period remained to be 30 days. The effect is that the termination. Did we lose you, Your Honor? I will pause here until His Honor returns. Oh, Your Honor is back.
Sorry, I lost you at the point at which you said Article 10 purposes. I don't quite know why. I'm obviously having some gremlins this morning, for which apologies.
That's all right. We all suffer from these issues. Then I'll cover that. That was the beginning of my second argument. So if you'll allow me to start from the beginning of that paragraph.
Yes, of course.
So as I mentioned, my second argument is in relation to the claimant's termination date. So the claimant mischaracterizes the termination of his employment. He resigned on 4 July 2024, exhibited as Defendant's Exhibit 2. Under Clause 6 of his contract, the notice period was 30 days. His employment therefore terminated on 3 August 2024 as a matter of law. That is the date on which the limitation period timeframe begins to run for Article 10 purposes. The defendant did allow him to remain on a so-called extended garden leave until 31 August 2024, but this was not a true garden leave under the contract. It was a discretionary goodwill extension offered by the CEO during a difficult period for the company, as offered to many other employees. It was akin to severance pay, not a contractual continuation of employment. The law of the parties is in the contract. The contract was never varied to extend the notice period beyond 30 days. The effect is that the termination date was 3 August 2024, and the limitation period under Article 10 thus expired on 4 February 2025. The claim was filed on 28 February 2025, which is 24 days out of time. That is fatal. The fact that the claimant continued to receive benefits during garden leave does not alter the contractual termination date. The extension was ex gratia, not contractual. This interpretation, exhibited as Defendant's Exhibit 3, has already been accepted by Justice Maha Al-Mahiri in the Small Claims Tribunal Case 520-2024, exhibited as Defendant's Exhibit 4. In that case involving the same defendant and the same set of circumstances, the court held that extended garden leave did not vary the contractually agreed notice period, and therefore did not affect the calculation of the limitation period. While that was a Small Claims Tribunal decision and not binding on this court, it is persuasive authority and demonstrates the court's own reasoning in similar circumstances. In summary, the claimant's case is beset by fatal flaws. On the court's jurisdiction, the parties expressly opted for Pakistani law and the Islamabad courts. That agreement should be respected. It is not comparable to the vague wording in Goel. On the applicability of the DIFC law, the DIFC employment law does not apply, as the claimant was not based in nor ordinarily worked from the DIFC, and the parties did not contract into it. Incidental benefits like dues, contributions, and an Emirates ID do not override Article 4. The claim is also time-barred. Even under the claimant's own interpretation, the claim is out of time. On the termination date, the true termination date was the 3rd of August 2024. Any extension of benefits was discretionary and did not change the law of the contract. For all these reasons, the defendant respectfully invites the court to dismiss the claim in its entirety and to award costs to the defendant. The court should not permit an out-of-time employment claim to proceed where the parties clearly chose a different law and forum, and where the statutory limitation has already expired. I thank the court for its time, and those are my submissions, Your Honor.
Thank you very much. Yes, Ms. Marr. Yes.
Your Honour, I presume that you're referring to me. It's Mariam.
I'm terribly sorry, Miss Mariam. Thank you.
It's okay, not a problem, Your Honour. Thank you to my friend for his arguments. It is the claimant's case that the applicant's case in this matter should be dismissed. The reason for this is twofold. Firstly, the DIFC courts have jurisdiction to hear the present claim under applicable relevant DIFC statutory provisions, namely Dubai Law Number 2 of 2024 under Article 14A, subsections 1 to 3. Secondly, Your Honour, the claim was filed within the statutory limitation period prescribed by DIFC employment law. I'll go into both arguments now with your permission, Your Honour. With regards to the jurisdictional challenge, it is my friend's assertion that Articles 4.1a and 4.1b of DIFC employment law apply to this instance. It is the claimant's assertion that, in fact, that the new law, which was introduced in March 2025 under DIFC Court Law Number 2 of 2025, replaces DIFC Law Number 10 of 2004 and also DIFC Law Number 12 of 2004, which is the Judicial Authority Law, Your Honour. The DIFC's jurisdictional gateways are now set out in Article 14A 1 to 3. This is referenced on page 203 of the claimant's bundle, Your Honour. If Your Honour gives permission, can I refer Your Honour to the relevant section?
Yes, just a second. Let me just get the my bundle is being a bit slow at the moment.
Okay.
Sorry, which
203, Your Honour.
it's locked at the moment. Wait a second.
Okay.
I'm going to just try. Just as I closed it, it was just opening up.
No problem, Your Honour.
Yes, 203.
Yes, Your Honour.
Hang on. Sorry.
It's okay, no problem, Your Honour.
Yes.
Can I refer Your Honour to Article 14, which is headed Jurisdiction of the DIFC Courts?
Yes.
So under Article 14A, Your Honour, the DIFC courts have exclusive jurisdiction to hear and determine, number one, civil or commercial and employment claims and applications by or against the DIFC bodies or DIFC establishments and those to which DIFC bodies or DIFC establishments are a party. Article 14A2 refers to civil or commercial and employment claims and applications arising from or related to contracts, whether concluded, completed, or partly within the DIFC, or which will be or should be performed wholly or partly within the DIFC, as expressly provided in such contracts. Article 14A3, civil or commercial and employment claims and applications arising out of or related to any incident or transaction relevant to the DIFC bodies or DIFC establishments, their own activities or those related to the activities of the employees in any of them that take place wholly or partly within the DIFC. Taking the article that I've just referred you to, Your Honour, even if the parties did not select DIFC jurisdiction within the contract of employment, it's still inferred from Article 14A, subsections 1, 2, 3, that the defendant's conduct and the DIFC regulatory structures infer jurisdiction. If I can give Your Honour a number of examples, the defendant is incorporated in the DIFC and registered with the DIFC Register of Companies. The defendant's office is located at FinTech Hive, Gate Avenue, Zone D, within the DIFC. Page 138 of the bundle, Your Honour, reflects the defendant's employment documentation, which clearly reflects the company address being located at the address that I've just given you. It also confirms in the share incentive plan and the grant agreement that the correct address is the DIFC address, and also at page 165 of the bundle, Your Honour, if I can refer you to this.
Yes.
Apologies, Your Honour, I'm just getting to the relevant section. At clause 9.1, it says that the parties...
Just a second, sorry, navigation. It's all right, my navigation of the bundle is seems to be very slow this morning, but...
Apologies, Your Honour.
It's not your fault. Yes, 165.
Yes. So the clause 9.15 refers to the parties irrevocably agreeing that the courts of the DIFC have exclusive jurisdiction to settle any dispute arising out or in connection with this agreement.
Sorry, I'm not on the right page. Sorry, I've got 165. What are you reading from?
It's clause 9.15, Your Honour.
I think I've got different page numbering. Hang on. 9.15.
Yes, Your Honour.
Governing law and jurisdiction.
Yes.
Yes.
So this clause, Your Honour, refers that the parties irrevocably agree that the courts of the Dubai International Financial Centre have exclusive jurisdiction to settle any dispute arising out of or in connection with this agreement, including disputes relating to the existence, validity or termination of the agreement or any non-contractual obligation arising out of or in connection with this agreement. So that would cover employment law. Essentially, Your Honour, the same applies to the grant agreement at page 178 of the bundle, Your Honour, which essentially has the same clause contained within the bundle. Also, Your Honour, the company issued the claimant with an Emirates ID, which is only issued to those granted visas to...
Sorry, so the share incentive plan.
Yes.
And which clause was that? Sorry, it's because the page references seem to have gone wrong. Which clause is it?
Clause 13, Your Honour.
13 point what?
13.6.
Well, how does one square the adoption? What do you say about this? Is obviously a choice of law clause.
Yes,
how do you square this choice of law of England and Wales with the of Dubai, the DIFC, with the England and Wales clause earlier?
Could your Honour refer me to the England and
Well,
Wales clause, Your
yes.
Honour?
If you go back to clause 9.15 at
Yes.
page, I think I've, you should it? Yeah, sorry, I've
165, Your Honour.
yeah, it's not 165 in mine, unfortunately. Don't know why not, but it's.
Apologies to interrupt, Your Honor. Perhaps the differences in the pagination is with the red pagination at the top and
Thank you. That's helpful. That's what so I've been using the red pagination, but anyway, I see it's 165. This is the agreement and any non-contractual are governed by the laws of England and Wales.
Yes, Your Honour.
That the parts irrevocably agree that the courts of Dubai shall have exclusive jurisdiction. So this has got a England and Wales governing jurisdiction clause in it, but a submission to the courts of Dubai.
Yes, Your Honour. I think what the intention of the claimant is in this argument is that it's partly within the DIFC jurisdiction, and that reflects that in that clause.
What do you mean by that?
I mean, Your Honour, although it's governed by the laws of England and Wales, the parties have reached agreement that the courts of the DIFC have exclusive jurisdiction to settle any dispute arising from this document.
Yeah, I mean this is a DIFC jurisdiction clause with an English choice of law clause.
Yes, Your Honour.
The share incentive plan is a DIFC choice of law clause.
Yes.
So my question, do you say that this, obviously you would say that the courts of the DIFC have jurisdiction in both cases?
Yes, Your Honour.
But how does one deal with the apparent conflict between the choice of law clauses? That's my question.
Thank you, Your Honour. I totally understand your argument with regards to the choice of law clauses. I think what the claimant's argument, and I'm not sure whether this is what you're referring to, Your Honour. I think when there is a conflict, what the jurisdictional gateways are saying is that if there is some kind of a link to the DIFC, it's irrelevant what the parties have agreed as to the choice of law clauses within the agreement. If there is some activity that has gone on partly within the DIFC, then the DIFC courts have jurisdiction to deal with the matter in those instances.
Okay.
Moving on, Your Honour, with your permission, if I can submit my next argument. The company also issued the claimant with an Emirates ID, which is only issued to those granted visas in the United Arab Emirates. I accept my friend's submissions that the defendant wasn't wholly working within the DIFC jurisdiction, but again, the articles contained within the new law refer partly to links to the DIFC, and the claimant was travelling between Pakistan and the DIFC employer within Dubai. Also, Your Honour, the defendant made contributions to the DIFC Employees Workplace Savings Dues Scheme, which applies only to DIFC employees. That's referenced, Your Honour, at pages 184 to 186 of the bundle.
Yes.
Thank you, Your Honour. Moving on to my friend's submission with regards to the case of Goal, it does confirm, Your Honour, that the generic or foreign form and forum wording does not displace DIFC jurisdiction, provided that the jurisdictional gateways are met. For the reasons that I've just explained, Your Honour, the jurisdictional gateways have been met in this instance. The approach aligns with Article 14A, which now collects and clarifies the jurisdictional gateways of the matter being heard within the DIFC. If I can refer, Your Honour, to a quote provided by the justices in the case, Your Honour, at page 293.
Yes.
Your Honour, are you at the relevant page?
Yes.
At clause 99, the respected justices advise it makes no difference to that conclusion that the parties specified the laws of the United Arab Emirates as the governing laws. That did not affect the construction of the courts of Dubai and the guarantees as essentially executed for the reasons already given. The choice of governing law is not determinative of the choice of jurisdiction. I think that just confirms the argument that I've just made, Your Honour, and effectively confirms that the jurisdictional gateways in Articles 14A 1 to 3 have been met with regards to jurisdictional matters. Turning to the point of the limitation argument, Your Honour, it is the defendant's case that Article 10 of the DIFC employment laws apply, that the claim must be brought within 6 months of termination of the employment. My friend has also correctly advised that there was a citational error made by the claimant's representatives, and the correct article that the claimant relies upon is Article 22 of the DIFC employment laws. This essentially states, Your Honour, that in relation to claims brought by an employee, if an employer has made an unlawful deduction from the employee's remuneration or otherwise failed to pay that employee remuneration to which the employee is entitled under their employment contract, a court shall not consider a claim under Article 20 unless it is presented to the court before the period of 6 months, beginning with subsection 1, in the case of a claim relating to a non-payment of remuneration by the employee, the date of the payment of the remuneration, or the date it should have been paid. Applying that law to the instant matter, Your Honour, the employee stock ownership plans, it's a given, Your Honour, that they form part of the employee benefit scheme. The defendant issued a notice of exercise of company call option on the 19th of August 2024, but did not make any attempt to make payment of the call option, Your Honour, even at the point of 9th of September 2024, when the defendant notified the claimant of the market value of the shares, no payment was made. It is the claimant's argument that the payment was due on that date when the market value was clarified. Still, no payment was made. Therefore, Your Honour, the limitation date, even if taken from the 9th of September, takes it up to the 9th of March 2025. The claim was issued and filed on the 28th of February, Your Honour, well within the limitation date. The case of Nemi and Nessim, Your Honour, is a case that the claimant intends to rely upon, and the claimant has respected the strict approach adopted by the courts in this case and brought the case within the 6-month limitation period.
So sorry, where's that in the bundle?
It's pages 297 to 303, Your Honour.
$297.
Yes, Your Honour.
All right, it seems to be.
Apologies, Your Honour. Is your bundle paginated differently?
Well, I've got two sets of bundle numbers. I've got red and I've got black ones. And I think the problem is you're using the black ones. And
apologies, Your Honour. My bundle is only paginated in the black, so my sincere apologies.
it's all right. It's just also doesn't seem to be completely uniform for reasons I'm not quite sure about as to. Let's try. Yes. Okay.
Yes, Your Honour. So my submission was simply that the claimant has respected the strict approach adopted by the courts in this case and adhered to the strict 6 month timeline
So
and
can you just give
limitation
me,
period.
so sorry, you just give me, so what do you say the critical date is?
The critical date, Your Honour, is the 9th of March 2025. As Your Honour, the defendant was advised and clarified the date on the 9th of September, clarified the market value, fair market value on that date.
But why? But the point which is taken against you is that that's not the date of the breach. That's simply a clarificatory date.
Yes, Your Honour, I agree with that. That's a clarificatory date, but my argument is even at that date, it's the claimant's argument that no payment had been made by the defendant.
Right.
At that point. Therefore,
but the breach had taken place in August.
On the 19th of August, Your Honour, that was when the defendant issued a notice of exercise of company of call option.
So that,
on the 19th of August.
But that was the date upon which the fair market value ought to have been provided, surely.
Yes, Your Honour, I agree with that. That was the date that it should have been provided. But the argument under Article 20, subsection 2, is that despite the fair market value being provided, no payment has been made to the claimant, even on the effective date of the point it was clarified on the 9th of September 2024.
I'm sorry, I don't understand this. Your case is that inadequate compensation was provided.
Yes.
You were told of the amount of this inadequate compensation on the 19th of August of 2024.
Yes, Your Honour.
And you say that's a breach.
Yes, Your Honour, on the basis of Article 20.2, where it says that in the case of a claim relating to a non-payment of remuneration, the fact that a fair market value of 0.01 was placed on the shares on the 19th of August does not constitute payment.
No, it doesn't. but it's irrelevant. I mean, you're not complaining about the failure to pay you the 0.01. You're complaining about the fact that the 0.01 is inadequate.
Yes, Your Honour, that's right.
And therefore, the breach takes place on the 19th of August.
I think what the point that the claimant is trying to make, Your Honour, is that the fair market value, which was a significant reduction, was an unlawful deduction from the employee's remuneration. And that clause is covered under Rule 20.2. Unlawful deductions are also covered under that. And the claimant constitutes that the fair market value being placed and undervalued at such a significant amount makes it an unlawful deduction.
But sorry to reiterate, that complaint arises on the 19th of August. It doesn't arise on the 9th of September.
No, I appreciate that, Your Honour. I think what the point is that the claimant is trying to make is that, and apologies if this is incorrect, Your Honour, but there was an unlawful deduction that was made and no remuneration was paid even up until the point of the 9th of September. And the claim was brought on the 28th of February, well within the limitation period, with the stance that no deduction, well, an unlawful deduction had been made and no payment had been made at that stage. Therefore, limitation has been brought within the limitation period.
What, I'm just looking at your claim form.
Yes, Your Honour.
Let me just find that. Sorry.
Your Honour, an amended claim form was filed and I've got the reference. I don't know whether this will assist you, pages 123 to 128 in the black numbering.
Let's have a look. One, two, three.
Yes, Your Honour.
Yeah, so the
To assist you, Your Honour, that would be 130 with the red pagination.
Thank you. I'm just looking.
Thank you. Which is, Your Honour, I would have redirected you, but I don't have the red pagination.
Don't worry. I mean, your claims are headed legal claims under DIFC employment law, breach of contract, wrongful denial of stock options, breach of share incentive plan and grant agreement, claim for damages, and then a claim under DIFC employment law. Now, on the face of it, you don't identify any specific breaches of the share employment plan or the sorry, the other.
I think that's at clause 3.3, Your Honour, breach of share incentive plan and grant agreement.
Well, the point I'm making to you is this: on the face of it, these are headed legal claims under DIFC employment law.
Yes, Your Honour.
And that employment law has the 6-month limitation period which we're talking about.
Yes, Your Honour.
If the applicable law was that of England and Wales in relation to the clause 9.15,
yes, Your Honour.
The limitation period wouldn't necessarily be the same.
No.
It would be 6 years.
Yes, Your Honour.
So do you have any case, and if so, what is it, to the effect that the choice of law of England and Wales allows you a longer period than 6 months? Because at the moment I'm struggling to see how you've brought your claim within the 4 months, sorry, the 6 months period.
Yes, Your Honour.
As we've identified.
Yes, so as you've correctly identified, thank you, Your Honour, clause 3.3 does state the breach of share incentive plan and grant agreement. And as the agreement and the share incentive plan refer to the law of England and Wales, as you've period.
But that's all very well, but the England and Wales choice of law clause,
yes, Your Honour,
has specific terms. Where do I find what breach it is that you're complaining of?
Your Honour, perhaps you could sort of clarify that for me. I'm not understanding what you're referring to.
This the grant agreement on the 10th of March of 2021.
Yes, Your Honour.
Gives you rights, or gives your client rights.
Yes.
For example, clause 2, granted a number of specific shares, the can exercise options, etc., and there are call options.
Your Honour.
What I don't see at the moment is what it is that you say is a breach of this contract.
Your Honour, I think what I was referring to was Rule 20.2 of the employment laws, and also.
No.
Apologies, Your Honour.
At the moment, the concern I've got is this. It may be that you've got difficulties under clause 20.2 of the employment laws.
Yes.
Because essentially, as I see it at the moment, the breach of which you're complaining took place on the 19th of August, and you didn't issue the claim form until the 28th of February, and that's more than 6 months after it.
Yes.
Now, one possible route round that is the adoption of English law and a breach, an identified breach of the incentive of the grant agreement. But at the moment, I don't see from your claim form what that breach is. You haven't said in breach of clause X, the price of 0.01 was put forward rather than some other price. Do you see the difficulty?
Yes, I do, Your Honour. Yes,
so
I do.
Do you have a case in relation to breach of the grant agreement? And if so, what is it?
Your Honour, if you can just give me a couple of minutes to refer to the share incentive plan, if you just bear with me, Your Honour. Is that okay?
Of course.
Yes, thank you. Your Honour, if I refer you to page 174, and this is the only breach that I can identify, page 174 of the bundle in the black pagination, it refers to the definition of an administrator. I appreciate that the share incentive plan confirms that the fair market value shall be decided by the administrator. Clause
so
3.
just go a bit more slowly.
Sorry.
So clause the clause 3 says the plan shall be administered by the chief executive officer.
Yes.
And the administrator shall have full power and authority to what's the relevant?
Shall have full power and authority to determine the fair market value.
Which one's that? Where's that in the? Sorry, it's probably just me being slow. Which subclause is that?
Sorry, bear with me. Apologies, Your Honour. Apologies, Your Honour. I can't find the relevant clause.
Well, 5.3.
Yes.
Where's the provision defining who determines the fair market value?
Apologies, Your Honour. I interpreted it as clause 3, which was the administrator.
Right. So just pausing there. So it would be, if necessary, make any other determination, take any other action the board deems necessary or desirable for the administration of the plan, would it? Or would it be something that doesn't look particularly applicable?
No, Your Honour, it doesn't.
Your Honor, I don't wish to speak out of turn, but if I may make a small comment.
Well, if you can help about the fair market value, please do, yes.
Well, no, Your Honor, that seems to be something that's a substantive matter for trial. At this application, we would be determining whether the application is within the time limits under employment law, or alternatively, if it were within the time limits of English law, whether that's applicable. I feel like we're delving into an analysis of the claim and the contract, which is...
Well, the issue is this. The issue is, what is this claim for? Now, the claim form, it's perfectly true, makes claims under the employment law. We've just looked at that at clause 3 of the claim form. But it seems to me that it includes claims for breach of contract, and the claims for breach of contract include a claim for breach of this clause. And if there is a claim for breach of contract, this agreement is governed by the laws of England and Wales, and therefore, at least arguably, is subject to a England and Wales choice of law clause with a 6-year limitation period, not a 6-month limitation. So I'm not determining anything substantial. I'm trying to look at the nature of this claim. But you'll have your turn to reply in a minute. At the moment, I'm just trying to identify whether there is a claim in this claim form for breach of this contract, and if so, what it is.
Your Honour, clause 5.3, as you quite correctly referred to, does cover this instance, but doesn't make reference to how to determine whether the fair market value is placed, the fair market value which has been placed by the administrator is fair, and how it in fact can be challenged.
But
maybe my friend.
Well, no, just it's your claim. I mean, it could be. I'm not. I don't think it emerges at the moment, but it could be that this agreement is subject to an implied term that the fair market value will be actually the fair market value, or at the very least that the fair market value shall be reasonable. But I don't see that being pleaded in your claim form. And it might be that if you had such a claim, you'd say, well, it's in breach of this. There's a English choice of law clause, and therefore I've got 6 years. And now at the moment, yes, that certainly does not appear at all clearly from your claim form. Do you want to say anything about that?
I think, Your Honour, and please forgive me if I'm disagreeing with you, the fact that clause 3.3 puts in the breach of share incentive plan and grant agreement, it says the defendant's actions in undervaluing the shares and not honouring its contractual obligations demonstrate a failure to act in good faith. I would presume that is under contractual law, and therefore 6-year limitation period applies under English law under the Limitation Act.
Well, all right. I will think about that. Yes. What other submissions do you have?
Apologies, Your Honour. My last submission is in relation to my friend's assertion that the last working day of the claimant was the 3rd of August 2024. and therefore the claim should have been brought by the 4th of February 2025. In his resignation, the claimant clearly stipulates that his last working day will be the 31st of August 2024, and that he should be placed on gardening leave. Well-known fact, Your Honour, that gardening leave forms part of an employee's contract, and that effectively a termination date cannot be before an employee's gardening leave. The defendant's bundle of documents themselves at this hearing confirm confirmation from the defendant that the termination date of the 31st of August was agreed. The final settlement statement, which I previously referred you to, Your Honour, which is at page 188 of the bundle, refers to the date as 31st of August 2024. Furthermore, the email confirmation of salary settlement from the defendant, which confirms the claimant was paid up until the 31st of August 2024, and also the dues statement that I previously referred you to, Your Honour, also confirms payment of pension contributions up until the 31st of August 2024. To sum up, Your Honour, it is the claimant's claim that the defendant's application should be dismissed for the reasons that I've discussed, namely, first, that the court does have jurisdiction under the new DIFC court law number 2025. Second, claim was brought within the relevant limitation period.
I lost you just then, I'm afraid. You just repeat what you said.
Yes. Secondly, that the confirmation that the claim was brought within the relevant limitation period. Certainly under, as you've correctly identified, Your Honour, the limitation period specified under English law, and certainly within the 6-year period, and that the costs of today's application should be the claimant's in any event. Thank you, Your Honour.
Well, just a second, let me just have a look at something. I want to just confirm something. Now, so your fundamental point is that the termination period was the 31st of August of 2024, and therefore, yes, so far as there is a claim under the DIFC employment law, it was made not later than 6 months after the relevant employee's termination date.
Yeah, Your Honour.
And within clause 10.
Yes, yes? Your Honour. Yes.
What breach of the employment law do you allege is relevant here?
regards to the last working day, Your Honour.
No. What is the employment law breach? The purpose of the employment law
Yes, Your Honour.
is to provide minimum employment standards for employees, promote the fair treatment of employees by employers, and foster employment practices that will contribute to the prosperity of the DIFC. And that then leads to the power of DIFCA to make regulations, etc. But what's at the moment, it seems to me that your claim is a contractual claim for breach of probably implied provisions of the share incentive plan, isn't it?
Yes, Your Honour. That's right.
So why is that a claim under the employment law?
I think what the claimant has asserted under the employment law, Your Honour, is that it's a breach for unfair deduction of wages, certainly under employment law, and the contractual obligation has also been cited in the claim form, Your Honour. So under the employment law, it's been an unlawful deduction from the employee's remuneration, which the employee stock option ownership plan forms part of the employee benefits.
I mean, have you got any authority to the effect that that is properly to be regarded as a breach of the employment law?
Unfortunately, Your Honour, no, I don't.
And all right.
Your Honour, I think the claimant's assertion is that an employee stock ownership plan is part of the employee benefits. There's been
that I understand, but I don't
Yes.
understand why on this view, misassessment of wages amounts to a misassessment of stock options amounts to an unlawful deduction of wages.
It formed part of the remuneration package, Your Honour, and therefore constitutes a non-payment of remuneration, and at the very least an unlawful deduction of remuneration.
Okay. Do you have any more submissions?
No, thank you, Your Honour.
Mr. Abreu.
Thank you, Your Honor. I do have a few things to say. So let me get started. If I can take you in the same claimants bundle to page 197 in the blank pagination.
Sorry, 197.
197, correct, which is the law that my learned friend has referred to. I'll wait a moment.
Sorry. 197. Yeah.
Should be Article 14. Do you have that before you, Your Honor?
I hope I'm about to.
Apologies, is that in the black pagination or the red pagination?
Correct. That's 197 black, 204 red.
All right. So this is Article 14. The DIFC courts have exclusive jurisdiction. Yeah.
Correct. Your Honor, my learned friend has made submissions on this article saying that the DIFC courts have exclusive jurisdiction, and that is what the wording says. but my learned friend seems to try to make the case that the IFC entities can now no longer choose other governing laws and contracts, which is not the case, and it's supported if we simply scroll down. If I can take you down the page to the next page, paragraphs B and C of the same law, and I will read from it. The DIFC courts have jurisdiction to hear and determine civil and commercial claims and applications where the parties expressly agree in writing to the DIFC court's jurisdiction, whether before or after a dispute arises, provided such agreement is made pursuant to specific, clear, and express provisions. My learned friend seems to think that this new law is replacing and re-legislating DIFC laws, which is incorrect. The effect of this paragraph is effectively to overturn Goel. That was an interesting case where courts of Dubai was deemed to include the DIFC, and what this law does, this Dubai law does, is say, hold on a minute, there needs to be an express reference to DIFC courts. So courts of Dubai, presumably in the future, will probably be ruled to refer to the mainland courts. Since,
but sorry, I completely understand your point that the employment contract refers to the courts of Islamabad, and presumably you would there say that C is applicable. The DIFC courts may decline jurisdiction to hear the following proceedings: claims falling within the jurisdiction of where the parties have agreed in writing to the jurisdiction of another court.
Precisely, Your Honour. That is exactly where I was going.
Right. So you say, so far as this is an employment claim, the parties have agreed to the jurisdiction of the courts of Islamabad. However, the claim form also refers to two other agreements. One is the grant option and the other is the share incentive plan. Correct?
Correct. And I will be making my rebuttal submissions
on that. Okay.
Or now, if you prefer.
Well, I got your point that so far as this is an employment claim, the parties have agreed to the courts of Islamabad. And right. You say, in simple terms, that's an express agreement. The parties are entitled to agree that, and the consequence of that is that any claim ought to be brought in Islamabad. That's what you say.
Correct.
Okay. Now, I understand that submission. There is the real complaint here appears to be an inadequate determination of the value of the stock options. Is that, do you agree with that?
Correct, Your Honour, yes.
Now, those stock options were granted to the claimant, who obviously is an employee of the defendant, and obviously as a consequence of the employment, pursuant, as I understand it, to two agreements, the grant and the stock incentive plan. Those two agreements both confer jurisdiction on the DIFC, correct?
One of them does. The other refers to English law.
Well, no, it refers surely, sorry.
To the courts, to the courts, yes, Your Honour, yes. If you're referring to the jurisdiction of the courts, correct, yes.
Yeah, so that gives jurisdiction. However, they have, one of them has an English choice of law clause, and the other one doesn't, correct?
Correct.
Now, am I right in thinking that it's necessary for your case that insofar as this is a claim for breach of the share incentive agreements and the grant notice, you need the 6-month period of employment, and you need to establish that the claim is brought after the end, more than 6 months after the end of the employment, correct?
Correct.
Now, 2 points then arise in relation to that. One is, insofar as it's a claim for breach of the grant agreement, the choice of English and Welsh law would tend to suppose that you've got 6 years, not 6 months. Yes?
Correct. If we assume that is the case, which we submit is not.
What you submit is not that the English choice of law clause is not valid, or that English law doesn't give you 6 years.
No, of course not. English law would give you 6 years. The crux of our submission, now that we are making this argument, obviously this argument we'll be dealing with this in the third case today, because that is when claimant's counsel puts forth such an argument. But we'll deal with it now. The defendant's case is that the grant agreement and the share incentive plan don't exist in a vacuum. If we are to take this course of action, this would be a reference to two contracting parties that deal with a commercial contractual agreement, and then we have a 6-year limitation period. By its very nature, an employment contract is a contract. So in theory, contract law would apply. But as Your Honor so rightly pointed out, employment law regulations around the world exist to regularize and increase and set standard minimums for employment contracts for the employee's benefit. So we submit that the employment law is actually the relevant law that applies, because this SIP and the grants agreement don't exist in a vacuum. Clause 4 of the claimant's employment contract refers specifically to the SIP and stock options. It is a well-established and common.
Sorry. Just where do we see clause 4? Which page is that at?
That will be. I do have the reference for our bundle, but just to make things a little bit easier.
Don't worry. I've got your bundle as well. Tell me which page that is.
1 moment, Your Honor. I'm also having some issues. I'm having difficulty opening up our bundle, Your Honor. We can simply refer to it's the same exhibit. I believe it's page 138 in black of the claimant's exhibit, claimant's bundle.
Thank you. Let's just have a look at that.
I'm also navigating there as well. So clause 4 would be on 139 in black and 146 in red.
Yeah. So you'd say.
So our argument, Your Honor, then is that, as I've mentioned, the stock options and those, follow-through agreements, they don't exist in a vacuum. They only exist because of
No,
this employment law. Yeah.
I understand that. And indeed, you presumably would make the point that clause 4 means that the exercise price will be determined at the discretion of the board of directors, and it's that discretion which is being questioned.
Indeed, Your Honor. I mean, of course, that is if this matter does go to trial, that'll be one of the main arguments we run. But certainly that is an argument we can run from today. And of course, the main argument is that, it's an employment law claim. That's what the claimant has put forward. And indeed, the benefit is an employment-linked benefit. It's a standard employment-linked benefit in startups around the world without the employment relationship, which is used to incentivize specifically employees. Then the follow-through SIP and grant agreement wouldn't exist.
I mean, the choice of Pakistan for exclusive jurisdiction is pretty odd, isn't it? I mean, you've got a British national, as I understand it, working for a DIFC or Dubai entity with a certainly Dubai employment provisions being given stock options which are subject to exclusive jurisdiction of the DIFC courts. What's Pakistan got to do with this?
Actually, Your Honor, it's not odd at all. The defendant is a Pakistani company. It's a Pakistani startup. And like most startups around the world, it recognizes the value of certain prestigious free zones. One of them is the DIFC. And like other startups, like other banks and financial institutions, they do have a presence in the DIFC to lend prestige to their operations, to lend credibility and authenticity. Certainly, one may not think a Pakistani-based startup is immediately something that wouldn't raise some concerns and nervousness with certain investors, which is why, per the claimant's own admission, the employee never worked ordinarily or was based in the DIFC. They were based in Pakistan. However, as their duties and other employees' duties necessitated, they traveled back and forth. And in fact, we'll see in the other application hearings today that this point is not even in dispute, because those contracts for other employees specifically refer to DIFC law and DIFC courts, whereas this employee was based predominantly in Pakistan. And that's why that governing law and that jurisdiction makes sense.
I understand. Okay. All right. And what do you say about the interrelationship? I mean, the oddity is that these documents, which are presumably drafted by your client, have a Pakistani jurisdiction clause so far as the employment contract is concerned, that a DIFC jurisdiction and choice of law in one case, so far as the grant and stock option are concerned.
I certainly cannot directly speak to the motives of my client in this matter, but it seems to me that in a startup world and a startup environment, English law and DIFC law, which is again effectively English, based on English law and common law, is extremely favorable and attractive to investors. They understand common law, they understand and respect the long history of English law and English courts and how the system works. And therefore, in a startup environment, and indeed in many international contracts, English law and DIFC or common law courts is the golden standard. So for the SIP and grant agreements, which are effectively investor-facing documents that a venture capitalist might look at, that would certainly be expected of any startup. But an employment agreement for an employee based in Pakistan it makes complete sense. The issues are a little bit separate. And as mentioned, there are other employees that are based in the DIFC, and their employment contracts, as we'll see today, are governed by DIFC law and DIFC courts. And in that case, that is relevant to have such governing law and jurisdiction clauses in the SIP and grant agreement.
Okay, all right. What do you say, therefore, is the true nature of the claimant's claim?
As we have seen from other pleadings and predominantly the current pleading, is they are quite upset with the valuation. There has been no claim that in fact, I would take objection to the characterization of this issue as an unlawful deduction. It is not. If anything, it is not payment of remuneration. Same article in the law. They've never ran such an argument saying you never paid us. They were paid.
It seems to me, if I'm in may respect, I mean, I agree with you. Their complaint is, well, I think their complaint is that in breach of some provision, the fair market value of the shares was wrongly assessed. That seems to be their core complaint.
Indeed, which is ironic since the company was effectively bankrupt at the time.
That's you were saying that's a matter for trial. If I may say so, that is definitely a matter for trial. Their complaint is that the value is wrongly assessed.
Correct.
I mean, their complaint is not that they weren't paid 0.0, whatever the amount was. I mean, but if that was their complaint, they'd be asking for, I don't know, 2 or 3 dirhams, presumably.
Indeed. You're absolutely right, Your Honor. That is the crux of the dispute. What the FMV is, what the fair market value is. And at the end of the day, that's a matter for trial. But before then, this is an employment law dispute. That's
why do you say it's very easy to say, but why do you say it's an employment law dispute? Just give me your key submissions on that.
Certainly. As I've mentioned, these stock options don't exist in a vacuum. They would not have existed had it not been for the employment agreement and clause 4 in the employment contract directly bestowing this benefit onto the employees.
Okay.
If we employ the but-for test, but for the employment contract, but for the employment relationship, these rights would not exist. It's simply an employment benefit, which is why the claimant correctly made their case as an employment law claim.
Okay.
It's not for the court to make the claimant's argument for them under contract law.
No. Well, I understand that. Now, I've seen and got your point that the employment law contract has got an exclusive jurisdiction point in to the courts of Pakistan, and if that ousts the jurisdiction of the DIFC courts, then that's the end of the claim. I've got that point. The second line is the DIFC jurisdiction clauses which we've seen in relation to the share incentive plan and the grant, and we've dealt with the position about England and Wales. Now, suppose that DIFC law does apply. Suppose there's a 6-month limitation period. Just give me why it is that you say the termination date was more than 6 months before the issue of this claim on the 28th of February.
Indeed, Your Honor. This is we had another case against another employee, same set of facts, same set of circumstances. The claimant in that case was Pascal, and the defendant ran the same argument, which is the company was going through a difficult time, and rather than giving an outright severance package or severance check, which again was, in a certain sense, a little bit inappropriate publicly facing, given that the company was in financial distress and in bankruptcy. But as a form of giving some sort of a severance crumb to employees that were resigning at the time, the CEO at his discretion sort of, extended the garden leave. Now, we submitted in that case, and Justice Mahal Mahiri agreed with us, that this did not vary the terms of the contract. This was effectively a severance payment. The terms of the contract state it's a 30-day notice period, which is a strict standard. And that's why we say that there was no artificial or actually extension of the garden leave. It was merely a gesture, a severance payment.
Right, now let me just have a look at your bundle.
Got our bundle up and running finally.
Can I just have a look, please, at clause 6 of the contract? Where's that, please?
That would be Exhibit D1.
Yeah. Page in your bundle.
Moment while it loads. You wanted clause 6, Your Honor. That would be page 12 in red of our bundle.
Right, so the requirement is to give at least 30 days notice. Where's the notice which was given?
Exhibit 2, page 31.
Well, I don't understand this. The clause requires giving of at least 30 days notice. He writes on the 4th of July saying the 31st of August, so he's given more than that. He's allowed to do that, but on the face of it, that means that the last day is the 31st of August and the claim is brought within time, isn't it?
Certainly, Your Honor, that's what the contemporaneous evidence would suggest. We are trying to mention that this was a company in distress, and there were oral conversations that reflected otherwise, mainly that the resignation was actually on the 4th, triggering a 30-day termination period, but it was agreed orally and even in writing that the extension of the garden leave would be to the 31st as a severance payment, simply to kind of keep the visa going, the health and benefits.
Where's the evidence in relation to that?
Unfortunately, there is no evidence at the time. The individuals that may have spoken to this point and provide witness testimony are no longer available to us.
Well, I mean, isn't that fatal? I mean, I've got your point about Pakistan and exclusive jurisdiction, but if the DIFC courts do have jurisdiction, then the one document we've got seems to me to show that this claim's brought in time.
On the evidence itself, yes, but as we submitted, we have a different point of view on this, and Justice Mahal Mahiri did agree with that. Again, not a binding decision.
Well, but hang on. Justice Mahal Mahiri, that was in the Small Claims Tribunal.
Correct.
And it was about a different set of facts. It was a different employee.
Correct.
And was different evidence before the court in that case.
Similar, identical argument, though, Your Honor, that this extended garden leave didn't alter the contractual 30-day notice period.
But the contractual notice is at least 30 days. And on the face of it, he's given more than 30 days notice. It seems to me you've got some difficulties on this point.
I will have to reserve my submissions at this point. Yeah.
All right. Is there anything more you want to say by way of reply?
Indeed, a few quick points, other than the fact that the Dubai law that my learned friend referred to doesn't support what she's saying. There is a point to be noted that the claimant does admit, and it's not contested, that the claimant was not based in or ordinarily worked from the DIFC, which is really the only standard that is relevant, Article 4 of the employment law. And that's it. That's it. That's the end of my submissions. We did cover the rest of my points when we discussed the applicability of English law. I thank the court for its time. Thank you, Your Honor.
Thank you. Now, I think what I will do is I will take a few minutes. It's now 20 to 12. I think we'll come back at 12 o'clock and well, I'll see, but I think I'm probably going to give an oral judgment in relation to this at 12 o'clock. So we'll come back on at 12 o'clock.
Thank you, Your Honour.
I think I'm going to remain on the link, but I'm going to turn off my camera and microphone.
Thank you, Your Honor. Your Honor, a quick question. Obviously, we were meant to have an application hearing at 11 and then again at 12. Do you envision we will continue with the other hearings today as well?
Yes, we're going to. My plan is to continue with the other hearings one after another until they were simply listed like that for convenience. I think this one may take a little bit longer than the other two. But that's my plan is to carry on and finish them all three today. It's just that I want a few minutes to think about my judgment in relation to this case.
Of course, I was just asking for a procedural. You at 12, Your Honor.
Thank you,
Your Honour. Thank you.
Can I just ask for the parties' help, please? In the course of your submissions, Mr. Algary, we looked at the provisions which allowed effectively to parties to contract in or contract out of DIFC jurisdiction. I can't actually find where we looked at that, and I'm sure it's my fault, but can you just give me a bundle reference to it, please?
Is this in reference to Article 4 of the DIFC employment law?
I think so, yes.
That wasn't included in the bundles. I can share my screen if you prefer.
I thought we did look at it in the bundles because I was looking at it on the screen.
Apologies, Your Honour. It's included in the claimant's bundle. I can give you the reference if you would like. It is pages 224 and 225 of the black pagination.
224 and 225. Hang on.
Thank you, Mariam.
No problem.
Oh, that's a bit stupid. Sorry, my bundle has been very slow. Sorry, I'm being
224, Your Honour.
124.
224.
224 of the claimant's bundle.
The black pagination, Your Honour.
That's in the middle of a judgment.
Is Your Honour, my bundle is paginated at 224, which is Article 4.
Sorry, this is the claimant's bundle.
Yes.
Your Honor, I believe the reference is 200 to 203. Again, I was trying to assist the court, but it's finally loaded. So let me see if I can assist you further. And apologies for the inconvenience.
No, it's all right.
Yeah, that's red pagination 207.
Okay, let me just have a quick look.
Is the start of the law, and I think Article 4 is on 20208. Red pagination.
Yes. Thank you.
Welcome, Your Honor. Sorry for the inconvenience.
No, it's all right. Navigating bundles is
always a challenge.
Yes. No, I'm sorry, it wasn't this that I was looking at.
Your Honour, are you referring to Article 14?
I may be. Let's have a look at Article 14.
Of the Dubai law about the jurisdiction?
Yes.
That's right, Tim.
That's 205, I believe, of the same bundle. So Article 14 is on 204, which is what the claimant referred to, and then further down in the same article on page 205 is B and C.
That's it. Thank you. Yes. I'm just going to turn my screen off for 2 minutes and then we'll come back. So and then I will give judgment.
Take your time, Your Honor.
Right. I'm going to give judgment now. In this case, a claim is brought by the claimant, Mr. Tayseer Ali, against Sadapay Technologies Limited. The claim is brought pursuant to a claim form which was issued on the 28th of February of 2025, and the claim is based upon, as is set out in the amended claim form, a contention that the defendant inadequately provided for the value of stock options which had been given to the claimant in his capacity as Chief Financial Officer. There are three relevant agreements in relation to this matter. The first is the claimant's employment contract, and that employment contract is to be found within the bundle that I have at page 142. Sorry, my bundle appears to have now under the employment contract, clause 1 provided for the claimant to be the Chief Financial Officer reporting to the Chief Executive Officer. Clause 2 provided for compensation of $5,500 a month. Clause 3 was for certain additional benefits. Clause 4 was for the grant of stock options with an exercise price per share to be determined at the discretion of the Board of Directors. Clause 6 of the contract provided for employment being for no specific time, with either party able to give the other party, quotes, at least 30 days notice of termination of employment. Clause 10 of the contract provided for the employment contract to be governed by the relevant laws of Pakistan, excluding laws relating to conflicts or choice of laws, and an agreement to submit to the exclusive personal jurisdiction of the courts in the Islamabad Capital Territory in connection with any dispute or any claim related to any dispute. That contract was entered into with effect from the 1st of July of 2021 and countersigned by the claimant on the 1st of March of 2022. The grant agreement under which stock options was provided was dated the 10th of March of 2021 and provided by Recital A that the company had adopted a share incentive plan, the terms and conditions of which were set out by the company on the March the 10th, 2021 and referred to plan terms. And the relevant provisions included at clause 2 the grant to the participant of a number of restricted shares. Clause 4 provided for exercise of options, and clause 9.15 provided this agreement and any non-contractual obligations arising out of or in connection with it are governed by the laws of England and Wales, the parties irrevocably agree that the courts of the Dubai International Financial Centre have exclusive jurisdiction to settle any disputes arising out of or in connection with this agreement, including a dispute relating to the existence, validity or termination of this agreement, or any non-contractual obligation arising out of or in connection with this agreement, and any proceedings arising out of or in connection with this agreement shall be brought in such courts. The claimant was duly allotted a substantial number of shares in accordance with the plan. The provisions of the share incentive plan, dated the 10th of March, contained provisions including the definition of good leavers and bad leavers, and provided that by clause 13.6, these plan terms and all grant agreements are governed by the laws of the Dubai International Financial Centre, and the effective date of the plan was the 10th of March of 2021. The claimant gave notice of his intention to resign his employment by an email on the 4th of July of 2021, which provided for the last day of his employment to be the 31st of August of 2024, provided the last day of his employment to be the 31st of August of 2024. The defendant seeks to strike out, or seeks to issue an application saying that the courts of the DIFC have no jurisdiction to hear this matter. There are two grounds for the application. The first ground of the application is that it is contrary to the provisions of the employment contract, which grant exclusive jurisdiction to the courts of Islamabad. The second ground of the application is that in any event, the application is brought too late because it is brought more than 6 months after the date of termination, in accordance with the Dubai employment laws. That therefore means that it is brought out of time. Dealing with the first ground, it seems to me, having looked at the amended claim form, that the essential claim which is made here is for breach of the terms of the agreements under which the claimant was granted the stock options. And in particular, as I see it, the claimant's essential contention is that the parties had agreed that the claimant would be entitled to the fair market value of the shares, and that fair market value was wrongly determined. The defendant's counsel makes the point that the company was insolvent and the value was fair, but that is a point which goes to the substantive merits of the dispute, not to the question of jurisdiction. It therefore seems to me that the essential nature of this claim is for breaches of the agreements under which the claimant was granted options. So far as those agreements are concerned, they both confer jurisdiction on, one of them grants exclusive jurisdiction to the courts of the DIFC. The other provides for DIFC law to apply, and the exclusive jurisdiction provides for the courts for the law of England and Wales to apply to the relevant agreements. Those exclusive jurisdiction clauses, or that exclusive jurisdiction clause, is incompatible with the employment contract, which provides for exclusive jurisdiction to the courts of Pakistan. As I say, it seems to me that the essential basis is actually in relation to the grant and share incentive plan. But even if I was wrong about that, it seems to me that there would be incompatible exclusive jurisdiction clauses. And in those circumstances, it does not seem to me that it can be said that there is an agreement to oust the jurisdiction of this court. And as the matter has been brought here, I would accordingly find that the parties have expressly agreed that the courts of the DIFC should have jurisdiction over the dispute. So far as timing is concerned, on the basis that this is a case pursuant to the employment law, there is a 6-month period for the bringing of the claim from the date of termination. The document which has been provided to me shows that the employment continued until the 31st of August of 2024, and the claim was therefore brought in time. The defendant's counsel seeks to persuade me that in fact this didn't reflect the reality of the position, and that this was in fact disguised severance pay. No evidence has been adduced in relation to that, and it is contrary on the face of it to the document which is relied on. Moreover, the employment terms provide for at least 30 days notice, and there was therefore nothing the matter with giving more than 30 days notice. It follows therefore that the claim is brought in time. I should say that that is on the basis that the Dubai employment law provisions apply. If it were the case that the law of England and Wales applied, it is agreed that there would be at least 6 years, or sorry, there would be 6 years in which to bring the claim. And so the claim is accordingly brought in time. It follows, therefore, that for the reasons I have given, I do not consider that this application is well-founded. The parties have not agreed to the exclusive jurisdiction of the courts of Islamabad in order to oust the jurisdiction, and rather have agreed to the exclusive jurisdiction of the DIFC courts. And moreover, for the reasons I've expressed, the claim is brought in time in accordance with the laws either of the DIFC or the laws of England and Wales. For those reasons, I therefore dismiss this application, and the matter will proceed to a trial. Right. Is there anything which now arises pursuant to that?
Yes, Your Honour, there's the issue of costs of the application for the claimant. I trust that you're in receipt of the statement of costs that was sent by the claimant this morning.
Let me have a look at that. Yes, I've got that. So let me just check I've got the right document. So the total is 44,100 dirhams. Is that correct?
That's right, Your Honour.
Yes, and that's what you apply for.
Yes, Your Honour, that's right.
And just as a matter of interest, what is the What was the defendant's statement of costs? So the defendant's statement of costs in relation to this matter comes to 59,141. Is that right?
Correct, Your Honor.
Yes, Mr. Albier. What observations do you have in relation to this application, please?
Your Honor, I would make the submission that their costs should be reduced pursuant to the to RDC 38.59 and 38.60, which grants the court the powers to reduce costs when there has been misconduct. There are two elements we'll point to. Number one, there have been persistent and unnecessary pedantic email correspondence by the claimant and claimant's counsel with regards to procedural issues, causing the defendant to incur unnecessary and pointless costs. Moreover, we note that the claimant breached the deadline set by the registry to file skeleton and bundles, and even though they requested the extension prior to the expiry of the deadline, the extension was not granted until a day later, thereby forcing the registry's hand and effectively reducing defendant counsel's time to prepare, which did cause prejudice. Other than that, other than these 2 points,
what's the email correspondence you refer to? Where can I? What's the complaint about that?
Your Honor, there have been many emails back and forth between the claimant and defendant's co-counsel with regards to the point regarding the bundle and skeleton argument. The defendant's counsel never received the registry's extension of time granted to the claimant's counsel.
Is this in the last few days that this has all been taking place?
Indeed, yes. However, the defendant's counsel filed on the correct deadline day, albeit 23 minutes late. But claimant co-counsel sought to penalize and request a punitive $200 fine for being 23 minutes late, which is unnecessarily pedantic and not in good faith. So there were many back and forth emails on this point that were unnecessary.
All right. Ms. Murray, do you have any observations about that?
Yes, Your Honour. Firstly, with regards to the unnecessary emails and the pedantic correspondence, my legal representatives have not provided me any evidence of such, and the defendant's counsel has not provided any evidence to the court in regards to this. With regards to late filing of the bundle, Your Honour, the request made prior to the deadline date, which was the 26th of August 2025. The request was made at UAE time 9:50 when the bundle was in fact due at 4 p.m. The registry approved the extension on the 28th of August at 2:23 p.m. Unfortunately, defendant's counsel was not CC'd into the email by way of courtesy, but it has been normal course of action that the parties haven't CC'd the other party into any correspondence to the registry, and the defendant's bundle, albeit sent on time, was not, the claimant wasn't made aware that the defendant had filed bundle. And in fact, I didn't have sight of the defendant's bundle until after the claimant's bundle was sent to the registry. Therefore, no prejudice has been given or made to the defendant, Your Honour.
This is an application for costs in relation to the two applications. It is, I think, accepted, but if not, I certainly find that the claimant is in principle entitled to an order for costs. The total costs sought are 44,100 dirhams. The defendant's costs are larger than that, some 59,000 dirhams. An application is made to reduce the costs for misconduct in relation to allegedly unnecessary email correspondence and in relation to correspondence about late bundle. in relation to that, it does seem to me that a request was made very late for an extension of time in relation to the bundle. I don't think there is any good reason for that, given how long this application has been up and running. However, it seems to me that the costs in relation to this would have been fairly minimal, and I accordingly make only a small reduction in the claim costs which are sought, and I grant the claimant its costs in the sum of 43,000 dirhams. Right. That is the first of the matters. Are we ready? It's now 20 to 1. Are you happy to go straight on to the second one, perhaps breaking for lunch at 1 o'clock? Is that satisfactory?
Yes, Your Honour.
Yes, Your Honour.
Very good. Let me just clear my decks of this one so that I can make sure I get the fact right of the next one. And we're dealing with action number 25 next, aren't we?
Yes, Your Honour.
Thank you. Just a second. Yes, and let me just get your skeleton argument up as well. Yes, Mr. Algari.
Thank you, Your Honour. May it please the court, I appear on behalf of the defendant, Sadapay Technologies Limited. This is the defendant's application to dismiss the claimant's claim as time barred. The essence of our case is straightforward. The court lacks jurisdiction because the claim was commenced outside the strict and mandatory limitation periods prescribed under the DIFC employment law. The statutory time limits are not matters of discussion. They go to the heart of whether this court may even entertain the claim. Firstly, I will deal with the claimant's objection to this application. The claimant contends that the defendant's jurisdiction challenge is procedurally defective because it was filed outside the 14-day period prescribed by RDC 12.4 paragraph 1. With respect to submission is wholly misconceived for two reasons. Number one, Your Honour's order of 24th of June 2025. Your Honour specifically ruled that procedural irregularities by either party would not be permitted to obstruct the overriding objective and the pursuit of justice.
Can I just see where that order is, please?
The order was not exhibited, Your Honour, considering that you've made it. I can share my screen.
No, don't worry. I'll get the order. I've got the order on the court file.
24th of June was the date of your order, Your Honor. If that assists you.
I've got it.
The relevant paragraphs are 4 and 5.
Right, so the defendant shall file its application to contest jurisdiction as indicated in both cases within 14 days from the date of this order. So that was on the 24th of June. Yes? Sorry?
Correct, Your Honor, yes.
And when was the application filed?
The application was filed within time.
Within the 14 days.
Correct. One moment. I believe the 30th. Yes, correct. The 30th of June.
Right. So your case is simply that there was the initial application about the amended statement of case and so forth, and the court has already said that it shall be filed within 14 days.
Indeed, Your Honor, yes. The original 14-day deadline was extended by Your Honor's order to simply, rectify the procedural defects in the application and move forward with something substantive.
Well, I mean, it wasn't just that, wasn't it? It was that I effectively allowed the claimant to submit amended statement of case documents with a valid statement of truth, and ordered you to pay the claimant's costs of that, but then required the filing of an application as indicated within a defined period. So you'd already indicated you were going to contest jurisdiction, and then I made provision for that.
Correct, Your Honor, yes.
Yeah. Okay, so I've got your point in relation to that.
Excellent. Further, there's another point, which was if indeed there was if the claimant genuinely considered that order to be procedurally improper, its sole recourse was to seek permission to appeal, and it did not do so. So to attempt to re-argue the point in written and oral submissions today is not appropriate. Next, I turn to the claimant's submissions on the applicability of the IFC law and jurisdiction. The claimant takes time in their skeleton argument to argue that the IFC law applies when this is not contested in this case. The defendant accepts that the IFC law is governing. This is explicitly provided for in Clause 8 of the employment contract, which I'm happy to take, Your Honor, to that if you prefer.
Sorry, what I was just looking at something else. What were you offering to take me to?
The claimant makes an argument that the IFC law is applicable and that the IFC courts have jurisdiction, but this is something that's not controversial and not in contention. Clause 8 of the employment contract does refer to the IFC law and refers the matter to the IFC court's jurisdiction. So there's no controversy on this point. It's a very short argument.
Yeah, okay.
Accordingly, just to kind of speed up and make use of the court's time efficiently, I'll just now dive into the crux of this matter and make my arguments in relation to the time-barred nature of the claimant's claim.
Well, your claim is very simple, isn't it? It's that the contract, the contract termination took place more than 6 months before the claim form was issued. That's not disputed. And secondly, that any relevant breach also took place more than 6 months before the claim form was issued.
Correct, Your Honor. Yeah, the argument is identical with regards to Article 10 and in lieu of Article 10, Article 20, subparagraph 2 of the employment law, yes.
Yeah, and your case is that the breach didn't crystallize on the 9th of September. Any breach occurred on, I think,
19th of August.
19th of August, yeah.
In fact, in this present case, there is a direct quote from the claim form where this is admitted. So I'll quote directly here: on August 19th, 2024, the defendant exercised its call option and repurchased the claimant's 72,000 vested shares at a price of $0.001 per share, despite evidence that the company's valuation was substantially higher. So there's an admittance on that point. But yes, Your Honor, that brings my submissions to a close. I believe we have covered the same point extensively in the previous hearing.
Yeah, okay. Let me just have a quick look at the claim form here. In the claim form at 3.4, the claimant does refer to the SIP and grant agreement, which I referred to in my previous judgment. Are those exhibited in this action?
I believe, yes, this was exhibited by the claimant. They are effectively identical. This is the whole purpose of having to have these hearings back to back. They're
right.
remarkably similar.
Right. Okay. So they're identical. So insofar as Dubai law applies, it's a 6-month limitation period, and it's outside the 6-month period. What about the reference to English law in which one is it? Is it
grant agreement is English law, yeah. SIP is the IFC law.
Have you got a reference in the bundle to those, please? In the bundle in this case, to those, please.
I believe that the grant agreement is 101 to 112
in whose bundle?
In the claimant's bundle. Is the grant agreement. Exhibit 15 and 14 is the SIP. So that would be page 118, red pagination. Clause 9.15, identical. Your Honor, our argument is the same, which is ironic since you've already ruled on this point, but it's the fact that the SIP and the grant agreement do not exist in a vacuum. They are employment law benefits.
Well, I haven't ruled against you on that. In the last case, it didn't avail you because I found that it was within the 6-month period. So 13.6, these plan terms and all grant agreements are governed by the law of the Dubai International Financial Centre. So that would be, you would say fine, because it's 6 months, and the claimant in this case is out of time.
Correct. Starting with assuming, of course, that the alleged breach happened on the 19th of August.
Yeah. No, I mean, sorry. Yeah. Assuming against your opponent that the relevant breach was on the 19th of August. Yes.
Indeed, which means the limitation period would have expired on the 19th of February, and the claim was filed 13 days later on the 4th of March.
And you would presumably say that insofar as clause 9.15 purports to apply the law of England and Wales, it's incompatible with the other choice of law clause, and certainly doesn't contain a clear change in what you otherwise expect to be the law, which would be the law of the DIFC to which the parties have submitted.
Correct. There is an incompatibility. But again, this is secondary to the primary issue, which is the applicability of the DIFC employment law in specific.
Yes, but you're saying that the employment law does apply, and that's because it's all part and parcel of the employment law contract. That's your submission, isn't it?
Correct, Your Honor. Yes, an almost identical clause that bestows the incentive, the grant, the stock options as an employment benefit in the employment contract.
Yes. Now, as I say, you made the same submission last time. I didn't have to determine that because I found that the claim was within 6 months in any event, so it didn't matter. But here, the question is whether this is an employment claim does matter, because you would say if it is an employment claim, it's 6 months, unless, as we've just discussed, there's a clear alternative choice of law applied, correct?
Indeed, Your Honor. It really boils down to, in this case, whether you consider, from our point of view, that the but-for test applies, and but for the employment contract and the employment relationship, those two agreements wouldn't exist. Or if you take the claimant's side, submissions, which is that they are independent, I believe, don't want to speak out of turn, that they are independent, and therefore English law applies, and of course the limitation period there is 6 years. That is effectively, and correct me if I'm wrong, Mariam, that is effectively the two sides of the argument.
Well, but you've also got the point that the plan and the grant contain two different choice of law clauses, and in those circumstances, regardless of the employment law context, the correct applicable law is that of the DIFC.
Correct.
Yeah. All right. Anything else you want to say in relation to this?
No, Your Honor. I believe I already, again, because the cases are 95% identical, they're 5% differentiation is the dates. But just in case, I will reiterate the dates relevant to this case, which is, of course, as we know, 19th of August, 2024 is when the alleged breach occurred, which means the limitation period remains to be 19th of February 2025, In this instance, the claim was filed on the 4th of March 2025, 13 days late. And that, Your Honor, indeed is the full amount of my submissions.
Yes. All right. Thank you very much. Yes, Ms. Miriam.
Yes, Your Honour. I think my arguments with regards to RDC Part 12.4, 12.5 have been dealt with. Unfortunately, I wasn't made aware of your respected order dated the 24th of June, allowing the parties an extension, but essentially, for the sake of completeness, the point was that the acknowledgement of service was dated the 19th of March 2025. The last date to make an application was the 2nd of April, but the application was made on the 30th of June. I've now become aware that this was agreed with your permission and that an extension was granted. Is my understanding of that correct, Tim? Unfortunately, I don't have the order before me.
Well, I think just to help in relation to this, what happened is that there was an application by the defendant that the statement of claim was defective because it wasn't properly verified by a statement of truth. And the order which I made on the 24th of June was on the defendant's application seeking a strikeout. And there was a hearing on the 28th of May where I dismissed the strikeout application, but required an amended statement of case with a valid statement of truth within 14 days, and then ordered the application to contest jurisdiction as indicated in the acknowledgement of service within 14 days. I think that's the position. I don't think there was an agreement to that effect. I think that's what the order was, which the court made.
Thank you, Your Honour. I think with the court's order being made that there'd be an application made subsequently 14 days thereafter, I think the RDC challenge therefore becomes inapplicable.
Yeah. Okay. So on the substance.
On the substance of the claim, Your Honour, I think the arguments are pretty much same with regards to the limitation argument that the defendant exercised the call option on the 19th of August 2024. As you correctly stated, with regards to what defines the fair market value of the shares, as we've previously stated, and this runs into the territory of contractual issues and unfair contract terms. It is noted, however, Your Honour, that at the time the defendant exercised the call option, the company's fair market value was established at USD 36 million. And I note that the company was sold before this date. It's also the defendant's assertion that the fair market value of 0.01 per share contradicts independent 4098 valuations and market data.
But this all goes to the substance, doesn't it? Not to the issue of jurisdiction.
Your Honour, just to make a point that the jurisdiction point is that, you know, that the essence of the claim rests with the fair market value, which hasn't been established because the defendant has failed to issue or transfer the shares despite the claimant paying the appropriate value on the 11th of July 2024. Therefore, effectively, to date, remuneration hasn't been paid. And therefore, the claim isn't statute barred.
Can we have a look at the relevant provision, which are you looking at the employment law for these purposes?
I'm essentially looking at breach of contract claim, Your Honour.
Yes, and I understand you say that the claimant failed to pay the correct amount following the exercise of the option on the 19th of August.
Yes, Your Honour.
When do you say the claimant was obliged to, sorry, when do you say the defendant was obliged to pay that value?
Certainly up until the point of 3 months after the claimant's employment, Your Honour, but the fair market value hasn't been paid. There hasn't been an exchange of payment or remuneration if we're looking at it from the point of view of employment law.
Yeah, no, I understand that, but when do you say that breach first occurred?
Breach firstly occurred when the defendant exercised the call option, Your Honour, because
on just to be clear, on the 19th of August.
The defendant's breach, Your Honour, yes.
So if you look at Article 22,
Yes, Your Honour.
what provision do you rely on?
We rely on the provision, Your Honour, that remuneration has not been paid.
Well, but sorry, which, in relation to a claim brought by an employer has made an unlawful deduction, so you're saying there was an unlawful deduction?
Yes.
Or otherwise failed to pay that to which is or received a payment, could not consider unless presented at beginning with, in the case relating to a deduction or non-payment, the date of payment of the remuneration from which the deduction or the date on which the remuneration should have been paid. Well, that's the 19th of August, isn't it? Page 143 or 12, it's 143 of the red bundle.
I think it's the claimant's assertion, Your Honour, that it should have been the 9th of September 2024 as the claimant disputed this, and it was clarified yet again. But the claimant has also always disputed this and shouldn't be prejudiced in bringing a contractual claim. And it's the claimant's assertion that the 6-year limitation should apply.
And your your claim form specifically refers, I mean, I think wrongly, to the DIFC employment law. And therefore you yourself are categorizing this as an employment law claim, aren't you?
If Your Honour, bear with me a second, I'll just refer to the amended claim form. Your Honour, isn't 3.4 a separate category breach of the share incentive plan and grant agreement? I am slightly confused as to how that could come under DIFC employment law.
Well, I mean, you say in as 3.5.2, as per DIFC employment law, the 6-month limitation began no later than the 9th September. So it seems to me that you are expressly asserting that the employment law applies to this claim, when the claimant became fully aware of the defendant's refusal to provide fair market value for the shares.
I think, Your Honour, if the contention is that employment law does apply, then the claimant will place the date of the 9th of September 2025 being correct.
Just a second. Sorry, I'm terribly sorry. Just give me a second.
Okay.
Sorry, I'm terribly sorry about that.
No problem, Your Honour.
All right. Well, look, it's 1:05 now. I think we'll take an adjournment for lunch, and we'll come back at 2:05. So I'll see you both again at 2:05.
Thank you, Your Honour.
Understood. Thank you, Your Honour.
Good afternoon.
Good afternoon, Your Honour.
Good afternoon.
Miss Mariam, I've been looking at the pleadings in this case.
Yes, Your Honour.
It does seem to me that you have expressly cast this as a claim under the DIFC employment law with a 6-month limitation period. And that seems to me to be the case in both the claim form and your skeleton argument. And your arguments have been to the effect that you're within that time. But if you're wrong about that, I understood you before the short adjournment to be making an alternative case, which is actually very similar to the third case, which is the sorry, I've forgotten the name of the third claimant, but the case where where it said that this isn't a claim under the employment law, but it's, well, in the third case it said that it's a claim pursuant to English law, and therefore there's a 6-year limitation period. But I rather understand from what you were saying that you want to assert that it is indeed a claim, either presumably to which English law applies, or alternatively, that this isn't a claim under the employment law, but rather is for breach of a separate contract provision. Is that right?
That's right, Your Honour.
Right. Well, I'll hear in a minute from your friend as to whether or not he can deal with that today, and if not, what the consequences are. But can we just look at clause Article 10 of the Dubai employment law?
Yes, Your Honour.
And this isn't on the application of English law, but it's on assuming this is all governed by DIFC law. Subject to Article 22 and Article 61(2), a court shall not consider a claim under this law unless it's presented to the court either during an employee's employment with an employer or not later than 6 months after the relevant employee's termination date. Now, neither in this case or the next one, as far as I can see, have either party submitted authorities considering what is meant by a claim under this law. I mean, the employment law contains a lot of rights. I was just reminding myself of them. But you presumably would be saying it's not a claim under this law, or it's a claim for breach of two separate contracts, and it's not a claim, for example, for unlawful discrimination and so on and so forth. Is there any authority in relation to that?
There isn't, Your Honour. I was doing some research on this point last night, but I couldn't sort of find any authorities on it. But that is, in fact, what the claimant's assertion is. You're absolutely correct.
All right. And what do you say about I think I'll put it. Would you want to put an assertion forward in this case that there's alternatively an agreement on English law in relation to this matter or not?
Yes, Your Honour.
Right. And do you accept that that would require you to amend your claim form? Sorry, I didn't hear your answer.
Yes, Your Honour.
Thank you. All right. Well, I think what will be convenient is I'll hear from Mr. Al-Gharawi now. Mr. Al-Gharawi, you don't need to address me in relation to the time of the breach and the fact, therefore, that the breach took place on the 19th of August and the claim form was issued after that date. You also don't need to address me that the claim as formulated in this case is said to be under the employment law, and there's an express acceptance of a 6-month limitation period. And it follows, therefore, that I consider that despite what Ms. Miriam has said, on the face of the claim form, this was issued too late. However, it seems to me that there is a desire to put forward, I think, two alternative positions, both of which I think arise in the third case. The first is that the claim is not to be categorized as being brought under the employment law. And the second is that English law has been adopted, and that provides for a 6-year limitation period. Now, first of all, I'm sorry, I should say this. I'm minded to think that if those claims be to put forward, they need to be identified properly, and that will have to be an amended pleading dealing with those matters. No doubt we can talk about the cost consequences of that. But first of all, are you in a position today, in this case, given the third case, to deal with the question as to whether or not this does or does not arise under the Dubai employment law? Sorry, the DIFC employment law. Sorry.
Absolutely. No, certainly, Your Honor. I mean, as you've correctly pointed out, we are effectively bleeding into the third case here, where this argument is fully put forward and actually put forward by the claimant. So I have prepared some arguments against this. So let me begin by first stating that Clause 4 of the claimant's employment contract, as we've seen before, it specifically entitles the claimant to participate in the share incentive plan. So the SIP and the grant agreement are not independent commercial instruments. They flow directly from and are inextricably linked to employment, as I've mentioned before.
Yeah, I understand your submission on that. Just before you get there, and I'll let you go on to that in a minute. Are you aware of any authorities which deal with the question of what is meant by, well, the provision I just quoted under the employment law?
Your Honor, I concur with my learned friend that no, there are no authorities. But as I'll get to it, we actually don't need the guidance of authorities. There is some guidance in the law itself. So the IFC employment law is specific. It gives us a definition of remuneration, which I'm happy to take you to if you have a copy of the employment law with you.
Well, yes, I've actually, hang on, let me just get this. I've called up the whole of the employment law rather than just the sorry, now what have I done with it? Hang on. Just give me 2 seconds.
Yes, Your Honor.
Yeah, okay. I've got the employment law in front of me.
Is it the PDF version, Your Honor?
Yes.
Okay, then I believe I can guide you to page 41 of the PDF, which I think around halfway to the page.
Which is the definition of remuneration, the aggregate of an employee's wages and additional payments.
Correct. Which will then take me to additional payments.
Right.
Which I believe, I will scroll up together, is on page 34.
Any bonus, incentive, grant, commission, drawing, distribution, or any other payment made by an employer to an employee that is discretionary, non-recurring, or is calculated by reference. So where do you say that the proceeds of
Your Honor, this would be an incentive. I think there again, because there is no legal authority on this, you are perhaps setting precedent today, and we may argue if it falls under incentive or if it falls under grant. Of course, we would say it falls under an incentive. Share incentive plan is the SIP, and that's exactly what the stock options are intended to do. They're intended to incentivize the employees and participants in the plan. So this connection of the incentive, the stock plans, as additional payments, which are remuneration, coupled with the claimant's submissions in their claim form and skeleton argument, and their argument that this is under 20 paragraph 2, that remuneration has not been paid, that it should have been more, is pretty decisive evidence that this is an employment case. Of course, again, we reiterate that without the employment, there would be no SIP or grant agreement. I also, on this point, want to draw your attention, Your Honor, to the fact that...
Sorry, just go a little bit more slowly in relation to this, because...
Certainly. Well, so, Your Honor, I mean...
Sorry, when I say go more slowly,
my apologies.
What I'm actually meaning is I'm looking at things and...
my apologies. Sure.
No, don't worry. I mean, sorry, this statute gives rights of various sorts, which are statutory rights. So, I mean, this is purely an example, but if you look at, sorry, I've now just gone to the wrong thing. I think it's Article 35, which is on page
Sick pay, Your Honor, page 13.
Yes, thank you. Sorry, I was there and I then managed to navigate away from it. Yeah. Yeah. So Article 35 says, subject to the employment's command, an employer shall pay sick pay in 100% of the daily wage and 50%, etc. So that is an example of this statute creating a substantive right and an obligation of an employer to pay sick pay. And it seems to me to be perfectly plain that a claim under this Act for sick pay would have, if properly formulated, pursuant to Article 35, the employee was entitled to sick pay, the employer failed to pay it, and we've therefore got a claim. In other words, it will be a statutory claim pursuant to the obligations under this contract. And it seems to me that there will be no doubt that Article 10 of the employment law was applicable, and court shall not consider a claim under this law unless it's presented either during an employer's or not later, and that would be a claim under this law. And then in relation to 20, which seems to me to be a provision about unlawful deductions or otherwise failed to pay remuneration to which that employee is entitled under their employment contract or on this law, it's not entitled to consider a claim unless it's presented to the court before the end of 6 months periods. Now, therefore, you have a question as to whether or not this is a payment of remuneration. And if you're right that it's a payment of remuneration, then 22A applies and it's out of time. If you're wrong about that, do you have an alternative case that it's a claim under this law or not?
No, Your Honor. Our main claim, which is, at least in our opinion, the true position, which is that it's an employment claim brought by an employee. That is the only argument.
But forgive me, that doesn't answer the question, does it?
Well, Your Honor, you asked if there were any other arguments other than that, but there aren't.
Okay, sorry, I'm being unfair. All right. Okay. So that comes down to the provisions which you showed me in the schedule as to definition of remuneration and a definition of additional payments.
Certainly, and Your Honor has raised the question of, what is the, what is the definition of a claim under this law? And I believe that non-payment of remuneration, or whatever that may be, salary, as we've just seen, additional payments, which we submit the stock options are a part of, that all falls under remuneration. So that would be a claim under this law. And that is exactly what the claimant has put forth in the first two cases and this one as well. The only reason this wasn't put forth in the second case, as we'll see, is because that claim form was brought so woefully outside of the 6-month limit that a claim under contract law was the only way to save that claim. But to bring it back to the idea that this is an employment law claim and the SIP and the grant agreement are inextricably linked, I can draw your attention to several instances in the grant agreement and the SIP where employment is mentioned in those agreements. Clause 4.1 of the grant agreement.
Just go a little bit more slowly. If we're going to look at those, let's look at them.
Let's do that.
Forgive me. Let's do them properly. So let's first of all find them, and then let's look at them.
Certainly. Let me begin that. I think my first reference was clause 4.1 of the grant agreement, looking at the claimant's bundle.
Yeah.
That's the share incentive plan. We will come back to. That would be page 115 in red, 104 in black.
Always nice to have two numbers.
Just for efficiency, yes, indeed.
Okay, just a second. Yeah, so just sorry, let me just check what I'm looking at. So yeah, this is the grant. Yeah, and yeah, so clause 4, yep.
4.1, have you found it, Your Honor?
I've got 4.1.
So the participant may acquire the relevant portion of restricted shares vested in accordance with the vesting schedule up until 3 months after the last day of the participant's employment. So that is, well, in the grant agreement, the only reference to a participant's employment, but it is there nonetheless.
So let me just look at that. So that allows an individual to acquire shares up until 3 months after they've left the employment. So they've got vested rights, and they can buy the shares, or they can exercise the right to buy the restricted shares.
Indeed.
In clause 4.
Which I believe in this instance happened in July.
Yeah, so the participants, there's a schedule, but they'd obviously already done that during the period of their employment.
Indeed, yes.
Okay, so then
the argument for sorry, apologies. Simply the argument that I'm making here is that there is ties in the grant agreement, and I will come now to the share incentive plan. I'll take you to that as well once we're done here.
Yeah, I'm just sorry. I'm just going through the agreement. I'm just wanting to work out how this works. Yeah, okay, so this agreement effectively grants rights to have the shares and acknowledges the opportunity given within the terms of the plan to have the company call those shares. Is that a fair summary?
Correct. Yes. Yeah. So once the shares are exercised and purchased by an employee at any moment up until 3 months after the end of the employment, as we've seen, then of course there is another clause that enables a company to also exercise a call option at its discretion.
Yeah, and just which clause is that?
Clause 6, company call option.
So let me just look at that. So the plan terms. Yeah, so under this, the company acknowledges the rights with respect to the company and consents over any unrestricted. Were the shares they had restricted or unrestricted?
If I'm not mistaken, Your Honour, I think they were restricted.
I believe so, yeah. We are going a little bit in a different direction to where I was intending to take us, however.
Well, I'm sure that's right. I'm on an anterior point, which is trying to understand how this actually works.
I'm afraid you caught me off guard. That is quite complicated, and had we been at trial, I would have prepared far better.
No, don't worry. So company call option is defined where? Probably in the
Conditions clause.
Well, it may be in the plan, actually. All right, let's go to the plan then, please. Where's the plan in this bundle?
I believe the preceding exhibit. Beginning on page 103 in red, 92 in black.
Thank you.
Company call option means the call option automatically granted to the company in accordance with clause 5.3.
Okay, let me just have a quick look. Okay, right. Yeah, I think I understand how it works. Yeah.
While we are then in the SIP, if I can take you back to the definitions, clause 1.1 of the SIP.
1.1 of the SIP, yeah.
So this is a continuation of my argument that all three employment, SIP, and grant agreements are linked and they reference each other. If we look at the definition of bad leaver, there are multiple references to employment. The B, subparagraphs B, D, and E refer to the participant's employment. Further down, the definition of leaver refers to that as well.
Yeah.
Means a participant who ceases to work for, to provide services to, or to be an employee of, employee or director of any group company. And I could go on and on, but I think the point has been made that both of the agreements reference employment, which supports the fact that these agreements don't exist in a vacuum and are in fact granted to an employee as an employment benefit, hence why this is an employment law, the IFC employment law claim.
Yeah. Okay. Yes.
That's it, Your Honor. That brings my submissions to a close. I'll give us a quick summary that stock options are awarded through employee incentive schemes, and it's a classic form of an employee-linked benefit. So it would be artificial to segregate them from the broader employment framework merely because they are recorded in a separate instrument.
Yeah. Just give me a second. Okay. Yes. Miss Mariam, do you want to reply?
Yes, Your Honour. I note my friend's assertions that the documents are essential and form part of the employment contract. However, I beg to differ. The grant agreement and the SIP refer to the governance of the specific agreements in accordance with a completely different jurisdiction and a completely different law. In the case of the grant agreement, that wouldn't have been the case where, if it was the case that it was to be read in conjunction with the employment contract. These essentially are two different agreements other than the employment contract, which is in effect, and have their own remedies stipulated within the relevant clauses.
Yes. Anything else?
No, thank you, Your Honour.
I'm going to take 10 minutes and I'll give judgment in 10 minutes time. So again, I'm going to turn off my camera and microphone and come back.
Thank you.
Understood, Your Honor. Thank you.
Right, I will now give judgment in relation to this matter. This is a claim brought by Mr. Jonathan David Shepherd against Sadapay Technologies Limited. And the relevant facts are that the claimant was employed by the defendant as Chief Technology Officer pursuant to an employment agreement dated the 30th of June of 2020. The defendant gave notice of termination of employment on the 31st of July and put the claimant on gardening leave from the 1st of August of 2024, with his final working day being the 31st of August of 2024. The claimant issued his claim form on the 4th of March 2025, seeking compensation in relation to the shares vested under the defendant's share incentive plan. It is apparent from the claim form, together with the claimant's skeleton argument, that this was cast by the claimant as being a employment claim, and moreover a claim for remuneration, to which the provisions of the Dubai DIFC employment law number 2 of 2019 applied. As such, by reference to clause 22 of that law, it was said that this was a claim for an unlawful deduction from the employee's remuneration or otherwise failing to pay remuneration, to which the provisions of clause 22 little a applied, with the consequences that a court shall not consider a claim unless it's presented to the court before the end of the period of 6 months, beginning with, in the case of a claim relating to a deduction from or non-payment of remuneration by the employer, the date of payment of the remuneration for which the deduction was made, or the date on which the remuneration should have been paid as appropriate. 2 points were originally taken by the claimant in relation to this matter. The first was that the objection to jurisdiction had not been taken within 14 days of the acknowledgement of service. It's apparent that the claimant's counsel was not aware of the circumstances under which the defendant had originally complained about the terms of the signature of the claim form and the order which this court made in June of this year, which permitted reservice of the claim form and gave a specific time for the issue of an application concerning jurisdiction, and the contest in relation to jurisdiction was duly made within that time period. Accordingly, in the course of her argument, Ms. Miriam realistically accepted that that point was not open to her. She sought to persuade me that the claimant was not aware of the relevant breach until the 9th of September of 2024. Alternatively, that there was a continuing breach. It seems to me, however, that it is plain that on the pleaded and admitted facts, the relevant exercise took place of the relevant option on the 19th of August of 2024. And accordingly, that if this is a failure to pay remuneration within the meaning of clause 22A of the employment law, the relevant date would be the 19th of August of 2024, and the claim form was issued more than 6 months after that date. It follows that on the pleadings and indeed the skeleton argument in this case, on the claimant's own case, this claim would not be brought within time. However, in the course of her oral argument, Miss Miriam said that she wished to rely on an alternative argument, which was to the effect that the claim was not properly to be regarded as a claim for remuneration, but was rather to be a claim in relation to the breach of the grant agreement, which incorporated the share incentive plan. That grant agreement has an express DIFC jurisdiction clause and an English choice of law clause, although the plan has a DIFC choice of law clause. I asked Mr. Agre if he was in a position to deal with this new case, and he fairly conceded that he was, largely because of the fact that this matter has been listed with a third case in which this issue already arises. It seems to me, therefore, that it is appropriate to consider, particularly as the relief sought is the ending of this claim, whether there is here a case which ought to continue or not. In the circumstances, if this case does continue, it will be necessary for the claimant to, I think, re-amend the particulars of claim so as to make the case clear and to set out the way in which the claim is set to arise. I proceed, however, on the basis that the claim will be made on the basis that there was a breach of the grant notice and or the incorporated share incentive plan, and the question then arises as to the proper application of the relevant laws. In relation to that, the claimant's case, in relation to that, the claimant's case centres on, first of all, the provisions of the grant agreement. The grant agreement was made on the 10th of March of 2021 and was specifically between the parties to this case, i.e. the defendant and the claimant, Mr. Shepherd. In that agreement, by recital A, it was recorded the company has adopted a share incentive plan, the terms and conditions of which are set out in the plan are terms adopted by the company on the same date. And the recitals then recorded that the company has the ability to allocate restricted shares, and it's a requirement of the plan terms that a grant agreement be entered into. And by D, the company wishes to enter into this agreement for the purposes of the plan terms with the participant to set out the terms and conditions upon which the participant is to be provisionally allocated restricted shares and potentially unrestricted shares, and the participant, by executing this agreement, provides their consent to the plan terms and the terms and conditions of this agreement. They're then followed by way of relevant parts of the agreement, clause 2, which was the grant by the company to the claimant of a specific number of restricted shares, and by clause 2.2, the plan terms were incorporated by reference into the agreement. And any unrestricted shares were to have the rights and be subject to the restrictions set out in the plan terms, the articles, and this agreement. The terms upon which the company could call for the shares were set out in clause 6.1, and that included the plan terms set out certain rights which should be conferred on the company by way of the automatic right of the company call option over any unrestricted shares that are issued. By executing this agreement, the participant acknowledges the rights conferred on the company with respect to the company call option as set out in the plan terms, and consents to the grant of the company call option over any unrestricted shares may be issued to the participant in accordance with the plan terms and this agreement. In clause 9.15, it was provided this agreement and any non-contractual obligations arising out of or in connection with that are governed by the laws of England and Wales, the parties irrevocably agree that the courts of the Dubai International Financial Centre have exclusive jurisdiction to settle any dispute arising out of or in connection with this agreement. As can be seen from the grant terms, the terms of the call option were specifically, the terms of the plan were specifically incorporated within the grant option, and the terms of the plan included within the definitions, the definition of a bad lever and the definition of fair market value the definition of fair market value meant the fair market value of the unrestricted shares as at a given date, as determined by or on behalf of the administrator acting reasonably, and the rights were then given in relation to the various shares. And by clause 5.3, it was provided if a participant holding unrestricted shares becomes a leaver at any time, the company should be automatically granted the company call option as at the participant's leaving date with respect to all of the unrestricted shares held by the participant, and the execution of the relevant grant agreement by the participant should be sufficient evidence of the participant's consent to the grant of such company call option. The company call option shall confer on the company the right to purchase any unrestricted shares held by the participant as at the participant's leaving date. The exercise price of the company call option in respect of each unrestricted share held by the participant shall be A, the fair market value of the unrestricted shares if the participant is a good leaver, or B, the par value of the unrestricted shares if the participant is a bad leaver. It follows, therefore, that in the circumstances of this case, I do not understand it to be in dispute, but that Mr. Shepherd was a good leaver. It follows that the grant option or the grant agreement entered into specifically provided for the company call option. That company call option required the administrator acting reasonably to determine the value. And it is that fair market value which the claimant wishes to dispute. It therefore seems to me that correctly categorized, this claim as to be regarded as a claim by the claimant that in breach of the provisions under which he was granted the shares, the exercise of the option took place at a figure which was not the fair market value, but was rather a undervalue, and accordingly that the administrator was not acting reasonably in acting in relation to his determination. And viewed properly, that seems to me to be the correct nature of the claim. That therefore calls into question how this claim is to be categorized. Mr. Algrieri submits, first of all, that the grant and the call option and the terms of the share incentive plan are all to be read together with the employment contract, which was entered into between the claimant and the defendant, and the terms of that contract. Sorry, can someone just give me the page reference to the employment contract, please?
Your Honour, I think it's page 80 of the black paginated bundle.
Thank you. The terms of that contract, which was entered into on the 30th of June, provided specifically by clause 4 that, subject to the approval of the board of directors, Mr. Shepherd will be granted an option to purchase 900,000 shares of stock, and the exercise will be determined by the board of directors or the compensation committee, and the option will be subject to the terms and conditions applicable to options granted under the stock plan, and the terms upon which those would vest are set out. The question therefore arises, first of all, as to the correct applicable law, second, as to the relevant limitation period. So far as the correct applicable law is concerned, Mr. Argy's submission is, first of all, that the correct applicable law is the law of the DIFC, and in relation to that correct applicable law, he accepts that this is not a claim under the law pursuant to clause 10 of the law, which provides that a court shall not consider a claim under this law unless it's presented to the court either during an employee's employment or not later than 6 months after the relevant termination date. But he maintains, as the claimant itself himself originally maintained, that it is properly to be regarded as a claim to which clause 20 applies. And the reason for that is that clause 22 provides, in relation to claims brought by an employee, that an employer has made an unlawful deduction from that employee's remuneration or otherwise failed to pay that employee remuneration to which that employee is entitled under their employment contract or this law, or received a payment from that employee in breach of Article 21, a court shall not consider a claim under Article 21 unless it's presented to the court before the end of the period of 6 months, beginning with, in the case of a claim relating to a deduction from or non-payment of remuneration, the date of payment of the remuneration for which the deduction is made, or the date on which that remuneration should have been paid as appropriate. And he relies in that context on the definitions which are set out in the attached by way of schedule to the law, and he relies first of all on the definition of remuneration, and the definition of remuneration reads the aggregate of an employee's wages and additional payments, and then on the definition of additional payments as being any bonus, incentive, grant, commission, drawing, distribution, or any other payment made by an employer to an employee that is A, discretionary, B, non-recurring, or C, is calculated by reference to the profits of the employer or an affiliate. And therefore, he says that the claim is brought more than 6 months out of time. So far as that is concerned, I consider that there are 2 points which show that that is not well founded. First, so far as the definition of additional payment is concerned, the definition which I've just read out refers to bonus, incentive, grant, commission, drawing, distribution, or any other payment made. Now, here it seems to me that the complaint is not properly to be, sorry, that the payment for shares is not properly to be regarded as a payment within the definition of additional payment. It is in truth the payment for shares in the company which the employee is being required to give up as a consequence of the exercise of the company call option. It does not seem to me that it can be said that it is of the same nature as bonus, incentive, grant, commission, drawing, distribution. And it also seems to me that it cannot be said that it is discretionary. It is not discretionary, it's obligatory. So far as non-recurring is concerned, it seems to me that although it is right to say it is one-off, it is not right to say that that is properly to be said to be non-recurring in the sense that is meant here. Rather, as I say, it is giving up rights, substantive rights to shares in the company, and it is not calculated by reference to the profits of the employer or an affiliate. It therefore does not follow, it does not fall within the definition of additional payment. In addition, so far as clause 22A is concerned, the relevant provision is in relation to claims brought by an employee that an employer has made an unlawful deduction from that employee's remuneration. It doesn't seem to me that that applies, or otherwise failed to pay that employee remuneration to which that employee is entitled under their employment contract or this law. It doesn't seem to me that that applies either, although I fully accept that the employment contract provides for the grant of options. It seems to me that it is plain that the payment which Mr. Shepherd was entitled to arises not under the employment contract, but under the terms of the grant of the options which he was contractually entitled to, which incorporate the share and incentive plan and indeed the company's articles. And so it follows that even if this were remuneration, it is not remuneration which the employee is entitled to under the employment contract or this law. It therefore follows that on the assumption that Dubai or DIFC law applies, the relevant limitation period would not be 6 months, that would be 6 years. That makes it unnecessary for me to consider whether, given the tension between the terms of the call option and the grant, the relevant law to be applied is that of England and Wales or the DIFC, given the conflicting provisions which occur within the terms of the grant and the terms of the call option. It follows, therefore, that this claim has been brought within time. The consequence is this: the application will be dismissed, but it will be dismissed on terms that the claimant provides, I think it's a re-amended particulars of claim, which identifies the legal basis of the claim and which gets rid of the assertion that this is an employment claim to which 6 months applies, and I will otherwise hear the parties as to the consequences of the decision which I've made. Who wants to go first?
Your Honour, I will go first. Thank you, Your Honour. With regards to the decision that you've made, subject to the claimant agreeing, which is a very good result for the claimant, I'm sure that the complainant will comply. I think that we are satisfied with the judgment and order that you've made. Thank you.
I wasn't asking whether you were satisfied with it or not. That's
No,
what do you say about costs? I mean, that's
with
that's
regards to costs, Your Honour. I would, in order to be fair, the costs of the application be the claimant's. But with regards to amendment, the claimant do pay the reasonable costs of the defendant.
Right. Mr. Agri, I suspect you may have something to say about that.
Certainly, Your Honour. While we may concede at the moment that the application is being dismissed, it is going to result in effectively a reframing of the claimant's case, eschewing anything to do with employment and more specifically referring and focusing on contractual breaches. That does change the nature of pleadings in the case, and it is not foreseeable what costs we will incur in having to rejig and re-review everything in that length.
Well, your opponent has conceded that you get the costs of an occasion by the amendment, and that's obviously right. What do you say about the costs of the application?
That's my point, Your Honour. It's not how will we calculate the costs of the amended claim form. Are you suggesting that we make a submission on costs later?
I'm asking for what your submissions are.
But that's what I was getting to, Your Honour. Considering that we will be awarded our costs for the amended nature of the claim, then each party bear their own costs in regard to this application, considering we can't quantify our future costs.
Okay. Ms. Miriam, do you want to say anything about that?
Strongly disagree with that. Essentially, the claimant has been allowed to continue with the claim, albeit with a re-amendment, Your Honour. The costs of the application, I maintain, should be the claimant's, with the costs of the amendment to be the defendant's reasonable costs occasioned by the amendment.
Right. Anything else?
I reiterate the same. Apologies.
No,
I reiterate.
Sorry, I wasn't asking. I don't think you've got a right to come again, Mr. I was asking anything else from Miss Miriam. No. All right. On this case, the claimant has successfully avoided the end of this action, but has only done so by a last-minute change of case, which even postdated the skeleton argument. In those circumstances, she concedes that the costs of the re-amendment, costs of an occasion by the re-amendment, will be the defendants in any event. I, however, think that Mr. Albury is correct. In the circumstances of this case, the claimant has been granted an indulgence at the last minute, and in those circumstances, it seems to me that the proper order in relation to the costs of the application is that there be no order as to costs, and the consequence is that each party will have to bear its own costs in relation to the application. How long do you need for the re-amended particulars of claim, Miss Miriam?
Your Honour, if we could say 6 weeks.
That seems a rather long time.
Can we reduce that to 4 weeks, Your Honour? What
do you say, Mr. Albury?
We don't object to 6 weeks either. I believe we have several other arbitration cases, and I certainly know I have a hearing in 3 weeks. So That
So you're
doesn't
not
directly affect, but I don't mind the 6 weeks.
You don't object to 6 weeks?
No.
All right. Well, if you're not objecting,
it's a professional courtesy.
All right. Well, that takes you, I think, to the I think it takes you to the 15th of October, doesn't it? Right.
Bear with me, Your Honour. Yes, Your Honour, you're right.
Right. Well, the claimant should file a re-amended particulars of claim by the 15th of October. How long do you need for an amended defence, Mr. Arbery?
I don't believe we'd need another 6, so perhaps 4 weeks on top of that.
Right. Well, I don't think your opponent can object, as you've given out 6 weeks. So that would be the 12th, I think, of November.
If I can just check our disputes calendar. I should have done that first before speaking. Did you say, Your Honour, the 12th of October?
No, I said the 12th of November, because they've got until the 15th of October, and you've got until the 12th of November.
Apologies, certainly. Yeah, that's fine. Yeah, 12th of October is fine, Your Honour.
All right. Well,
November. Sorry.
Anything else in relation to that?
And thank you, Your Honour.
No, Your Honour.
All right. Now, that then leads to the third case. And I think the effect, unless I'm wrong, of my decision in relation to the second case is that, let me just get rid of.
It would effectively be the same ruling, I believe, Your Honour.
I think that's right. The difference, I think, let me just, sorry, I'm just going to, just give me a minute just to clear my, just to clear my, right. Yes. I thought I got the case open, but I haven't. I apologize. So this is CFI 35, isn't it? Yes.
Yes.
And yes. Well, the consequence of that, I think, is that, as I think you realistically concede, Mr. Arbery, is that for the reasons I think I've given, unless there's any points of distinction, the consequence is that I would find that this claim is not barred And unlike the previous one, it seems to me that the claimant's case has not changed or hasn't changed in relation to this, because she accepts that she's outside the 6-month period, which might otherwise have been applicable. Is that right?
Your
Yes,
Honour,
Your
if I'm
Sorry, I think that's a question for Mr. Albury at the moment, because
sorry, Your Honour.
I want to see whether he accepts that the logic of my previous ruling in relation to this effectively disposes of this, or whether there are any points of distinction.
No, Your Honor, you're correct. It was going to be the same argument which we cloned for the previous hearing, in that the agreements are linked, but Your Honor has ruled against that point.
Yes, all right. Sorry, Miss Miriam, I cut you off.
Apologies, Your Honour. I think the only point of distinction is that in the amended claim form and particulars, I think the claim form has been correctly pleaded.
Yes, no, that's right. I mean, I was saying that
Yes.
in this case, you've taken it, and you've certainly taken it in your skeleton argument. Okay, well, it seems to me that I ought to give a brief judgment in relation to this matter. And it seems to me that, given that you accept the matters are the same, I'll do so by reference to the judgment I've just given. In this case, which bears similarities to case CFI-025 of 2025, which I have just determined, it is accepted that the claim form was issued more than 6 months after the relevant cause of action arose. However, for the reasons which I gave in my judgment in that case, it seems to me that on a proper understanding and definition of the DIFC employment law, this claim does not fall either within Article 10 or Article 22A of the employment law, with the consequence that the default period for the bringing of a claim is 6 years, and it is brought within time of that. And as in that earlier claim, I do not determine whether the applicable law is the law of England and Wales or the law of the DIFC, because so far as relevant for these purposes, they both contain 6-year limitation periods, given the conclusions that I have come to. It follows, therefore, I dismiss this application, and unlike in the previous matter, I do not require the service of re-amended particulars of claim, and the matter can proceed. Very good. That's the judgment. Now, what about costs?
I'll allow Ms. Miriam to go first as the victor.
Thank you, Tim. Your Honour, as the claimant has succeeded in dismissing the defendant's application, I would request that the cost of the application be the claimant's in this case.
Yes. Now, let me just get the amount you're seeking. You're seeking 48,300. And
yes,
let me just see what the defendant's costs were in relation to this matter.
Apologies, Your Honour. I think we were seeking 55,303 in this matter.
Were you? Let me come back to that in a second. The defendant was seeking 55,303, as I see it.
Apologies, Your Honour. I've got the defendants in front of me. Apologies.
Right. So they would have been seeking 55,000, and your costs are 48,300. Have I got that right?
Yes, Your Honour.
Right. Mr. Albury, what do you say about the claimant's costs?
Your Honor, I'd make 2 arguments. The first one being that while we acknowledge that the claim does not mention any employment law claims, we did put forward as defendants a argument in good faith that it would fall under employment law. And it was our position that the argument to go through DIFC or English law, as the case may be between the SIP and grant agreement, was used only to disguise the fact that under the employment law, there was absolutely no argument that it was within the 6-month time limit. It was nearly 3 months out of date. So it was a disguise, and our argument wasn't obstructionist, and it was put forward as a genuine agreement. So my first submission on costs is similar to the previous case. It should be the costs of each party, and each one would walk away. In the alternative, should your honor be minded to award the claimant their costs, I would reiterate RDC 38.59 and 60 regarding misconduct, the same points I raised in our first case, Tayseer's case, regarding the unnecessary pedantic emails and submission of the skeleton and bundles in a late matter.
Right. Anything you want to say, Ms. Murray?
Yes, Your Honour. With regards to the first point, my friend's first point.
You don't need to address the first point.
With regards to the second point, I don't have any submissions to make other than those made in the previous case.
Right. In this case, the claimant has successfully defeated the attempt to deny jurisdiction to claim, has not changed its case. The defendant asserts that it put forward arguments in good faith. I don't doubt that. However, that is not relevant to the incidence of costs. It put forward those arguments and it lost. And in principle, the claimant is entitled to the costs. So far as the quantum is concerned, the overall quantum is 48,000, which is 48,300, which is slightly less than the defendants of 55,000 odd. The costs in general seem to be reasonable to me. I accept for the same reasons that I did in relation to the first case, that some small deduction should be made from those. And I order in those circumstances that the defendant paid the sum of 47,000 dirhams to the claimant, which I assess as being the appropriate figure for costs. And unless there's anything else, those are, I think, the matters we need to determine today, aren't they?
Yes, Your Honour.
Good. Well, can I thank you both very much for the efficient way in which you have conducted this matter, and look forward to seeing you in due course.
Thank you, Your Honour.
Thank you, Your Honor.
Bye now.
Bye.